Yes.
I seek your Lordship's indulgence. Your Lordship, if I may be allowed to mention from part 2, item 1, if this matter may come up on Thursday or Wednesday, Your Lordship.
No, why?
Your Lordship, I had some personal difficulty and I've taken the consent of the council.
Okay, Wednesday.
In fact, Your Lordship, as per the order on 1st of June, this matter was to come up next week, I think.
I seek your Lordship's indulgence in mentioning part 2, item number 5.
Yes.
My Lord, on the instructions of the petitioner, I have submitted a rejoinder affidavit on Friday. So, my Lord, it has not been brought on the records. So,
Okay, put it in the record.
my Lord, if this may be taken up,
You can take it up today also, not a problem. It's your affidavit, you know what the contents.
my Lord. Next week, my Lord,
Why?
I have taken the consent of the.
But the consent of the court has not been given.
Yes, my Lord, that
Then?
is there, my Lord.
What is
However,
the issue?
my Lord, issue is that the petitioner has been dismissed from service. He's an MRB, Mizoram's Rural Bank officer. And
Dismissed for what? On what ground?
due to unauthorized guarantee of, yes, unauthorized guarantee of
Loan.
bank guarantees. Unauthorized bank guarantees. And here, my Lord, in the additional affidavit, he has in the rejoinder affidavit, he has submitted list of 42 MRB officers upon whom the respondent, the bank, had taken disciplinary actions.
Then?
That is what I have submitted before the court. So maybe the respondent would like to, my Lord, peruse the records.
That is for them to decide, not
My Lord,
you.
my Lord, I
Let
have,
them decide.
yes, I have spoken to the learned senior counsel. As a
Okay, right. On the prayer for adjournment made by the petitioner's counsel, who submits that he has taken the consent of the other side, list the matter after a week.
My Lord, I'm obliged.
Please mention a matter, my Lord. I'm seeking a relief of the court. May please mention a new matter, my Lord. I'm seeking an urgent listing for today, my Lord. Lord, this is with regard to a final argument which is being heard, my Lord, in the MCP case, Mizo Carbon Products, my Lord, going on day to day. My Lord, I represent 10 of the accused and I'm been arguing the matter. My Lord, the prosecution has filed a written submissions, my Lord. I have not been given a copy of it, of that. The statute says whenever you file something, you give me a copy. I'm not able to meet the case on
This
it.
is written arguments.
No, my Lord, they are reading, my Lord, something I do not even know. My Lord, section 314 categorically says that I have to be given it as to
No,
be
no,
exchanged.
maybe it's just an argument. He's put it in writing.
My
That's
Lord, I
all
do
for
not,
himself.
my Lord, it is imperative, my Lord, I will show.
Whatever you're arguing now doesn't have to be in writing.
No, my Lord, it is written, my Lord, they have given accused by accused all the written details of everything. They are reading from that. I am not been given a copy.
They are reading it from they can read it. It's their own document.
My Lord,
They can read it.
my Lord, the section 314 categorically says if I am only following the mandate, my Lord, the CRPC provides. The second, my Lord, the second grievance is,
Not today, not
my
today.
Lord, can I just make a request?
Not today.
My Lord, one request.
Tomorrow.
My Lord, I'm a personal difficulty, my Lord. That's what I said.
Yeah, that is not my problem.
My
Mister.
Lord, can I?
I've got enough. My plate is full for today.
My Lord, can I just one request? One request. I would have not bothered, my Lord. My Lord, the matter was fixed for 4 days. I was here for 4 days, my Lord, to argue this. It's 10 accused I'm arguing, my Lord. I'm in a personal difficulty. I have a predisposed arrangement, my Lord, in Japan, my Lord, to be there from Wednesday onwards. I requested the court to adjourn it just for 10 days. The court says, no, we will do it the whole week, my Lord. How can I, my Lord? It is that the hurry is that, my Lord, without giving me a copy.
It's
my Lord,
good that the court is doing it day to
no,
day.
my Lord, I'm saying, my Lord, only for 10 more days, my Lord, I will be back. I will be
I
back
don't
here. My Lord, I'm only requesting these.
Tomorrow.
My Lord, can it be then first on board so that I can go back? My Lord, there's only one flight available. Can it be first on board tomorrow, my Lord? Can I request that?
We'll see. Where is your mention memo? You give it for tomorrow. Let's see.
My Lord,
For admission, item number 1.
Your Lordship, before that, may I make a mention regarding one listing of one pending case this coming Wednesday, because this is regarding challenging of the law Adalat award, and Your Lordship had passed one order for depositing of 8.2 lakh,
Yes.
and they gave me one check which was returned due to insufficiency of funds. So they are having only 1 day more, that is tomorrow only. So in the meantime, if they don't do anything, then it may come upon Wednesday, because they have already, the petitioner also deceived me, my lord. I'm not happy with the way he dealt with me, in fact. So it's not good. It may come upon Wednesday, so in case
Item?
anything happens. This
Yes,
is
I did.
WPC 67 of
It is
2026.
fixed for which date?
It is to be taken up after list the matter on 2/7/2026, my lord, so 2nd of July. However, if it could come upon this coming Wednesday, I think that will be better if your lordship.
Okay.
Much obliged.
Item 1, please.
May it please your lordship, the conducting counsel, Mrs. Caroline Kilung-Oipu, has personal difficulty at the moment, so if the matter may be passed over for the time being, your lordship.
Who's having personal difficulty?
Mrs. Caroline Kilung-Oipu, your lordship, the government advocate who is conducting in this matter.
So what does she want?
Your lordship, if the matter may be passed over for the time being, and she will arrive in around 5 minutes. your
Next.
Item 2.
May it please your lordship, in the last, when the matter was last listed, your lordship, the Kala Khozol had to produce the order on the basis of which the reassessment was made on 14/10/2021, your lordship. If I may be allowed to produce the order.
This is.
Your lordship, the respondent is on seal number 13, your lordship. And the Kala had executed this order, your lordship.
Acha, this Kala had instituted this one. Not the DC. Huh?
No, your lordship, it is the Kala.
When was the where is the award passed by Kala? Which date? Award was passed on 15/3/21. Is it? You have no idea when the award was passed. You're doing a land acquisition matter and you don't know when the award was passed.
My lord, the arbitral award was passed on
Not
5th.
arbitral award, Mr. Counsel.
My lord,
I don't want the arbitrator's award. I want the award, the compensation award. When was it passed? We'll take it about some time. You please read your files. You don't really know the facts.
Item 3.
Yes.
May it please your lordship, I'm appearing on behalf of the state respondents. Your lordship, I've received the instructions to be filed for in the affidavit, your lordship. If I may be given a week's time to file the same.
Correct. Ms. Lalnundri submits that affidavit, that parawise comments have been received,
Yes, your lordship.
and she will be filing her affidavit on behalf of respondents, all the respondents,
Yes, your lordship, all the
on
state
behalf of all the
respondents.
respondents,
Your lordship, 1 week's time.
within a week. This is the matter after a week.
Much obliged, your lordship.
Item 4.
My lords, the counsel of respondent number 1 and 2 has some difficulty, so he has requested for adjournment.
This is an arbitration matter.
Lordship, as per the last court order, I was directed to obtain some documents from the office of the
Yes,
arbitrator.
yes.
I have obtained the documents, but I think everything has already been placed on record. These are just some comments given by Kara and
It
some.
is with regard to those 6 buildings, is it?
Yes, my lords, 6 building and escalation of the price, value of the land.
One contention raised by
Where is
the.
the award again? Page?
My lords,
Arbitral award.
arbitral award, my lords, 153. My lords, in this matter also, rate has been revised without any evidence. Further, it has also been revised for the category for which it has never been paid for. My lord, can see at page 163.
Yes, 7. You see, I need the arbitral award, the records of the arbitrator.
Lordship, I have.
Huh? You have got it?
Yes, sir.
That's all. That's all.
Apart from this, what they relied upon was the verbal hearing conducted by the.
So you see, it has enhanced the award amount compensation on the basis of 150 registered sale deeds. So I want to see if 150 registered sale deeds can be accommodated in this batch of documents.
No, no.
This is the record.
My lords, 150 register sale deed has been relied by Kala to
Kala.
pass the 3G award. He has not relied upon any sale deed. my
Acha, he
lords.
has not realized.
No, no, my lords.
That is by Kala.
That is by Kala, my lords,
And
as
the
per section
arbitrator
26.
has not given anything.
No, no,
That
my
is, what is, how, that is what I was saying. Okay.
And
That is by Kala.
Yes, my lords. And my lords, the category which has never been in a relief has also been enhanced, my lord.
What to do? The other side is not here. We'll see tomorrow.
Absolutely.
Right. They want to adjourn till what date?
Sorry, Lordship.
For today, they want to adjourn or
Yes,
what?
my lords, yes.
Okay,
They have some
Adjournment
difficulty
prayer has
for-
been made on behalf of the respondents number 2
One and 2.
1 and 2. List the matter tomorrow. It is surprising to note that while Kala had made the compensation amount on the basis of 150 registered sale deeds, the arbitrator has not made its enhancement of the compensation amount on the basis of any registered sale. This is the matter.
Obliged.
Item 5.
Further, Kala has produced the records.
My lords, in
No,
item
but then we will leave the arbitrators. He's for Kala, no? Or he's for the arbitrator?
for the Kala, my lords.
Yeah, we are for Kala. Now, what to do about? We need the arbitrator's record.
As per the last order, I had given direction to,
Registry.
no, to me to collect the
Then-
documents from the arbitrator.
Then
So
can't you collect?
I had done so, and
This is the one.
that was what was.
This is the arbitrator's records.
Yes, Your Lordship.
Okay, right. Mr. So has produced the not Kala records, say arbitrator's records today, and it's placed in the it's placed in the main file.
Yes.
That's all.
Apart from that, some office notes were there, but that is not the documents related.
Okay. Okay.
My lord, in
Item?
item number 5 also, the petitioner counsel has prayed for some time, my lords. Aldrin Zothan Moya.
Yes, madam. Here for whom?
My lord, appearing for respondent number 6.
6 is the YMA,
Yes, Central YMA, your lordship.
Central YMA. Why are you evicting people from their houses? Who are you to evict?
Your lordship, we are not directly involved in this matter, so.
Can you take the law into your own hands, madam? You have to answer that. You are not directly involved. Then who is involved? According to you,
Your lordship, the local YMA.
the local YMA,
Yes, your lordship.
and you have got no control over them, is it? Are you filing any affidavit or what?
No, your lordship, for this matter, we will not be filing for counter affidavit.
You will not be filing. Okay.
Your lordship, I'm appearing on behalf of the state respondents 1 to 5. We'll be filing an affidavit by Wednesday, your lordship.
You tell your DC and SP to make a report
Yes, your lordship.
with regard to this eviction.
Yes, your lordship.
It has to be there. Right. Adjournment prayer has been made on behalf of Mr.
Aldrin Zothan Moya.
Alonso Thanmoy, counsel for the petition. The petitioner has apparently been evicted along with his wife and along with her husband, or what? Who is it? Along with her husband and 5 children on the allegation of selling liquor. By the respondents number 5. Miss, your name?
Vanessa Handami.
Vanal Chandami, appearing for the respondent number 6,
Yes, sir.
bracket CYMA, submits that the respondent number 6 will not be filing any affidavit, as the action of eviction has been done by the respondent number 5, has allegedly been done by the respondent number 5, and respondent number 6 has nothing to do with the respondent number 5. Is it? Is that your case?
Your lordship, the state respondents are 1 to 5, and the 7, 8, and 9 are the village councils.
Okay. No, okay. Let me see. Okay.
And then the 8 is the Bungklang Wing
Okay,
Lai
as
branch.
the respondent
YMA.
number 6 has nothing to do with the eviction action undertaken by the respondents 7 to 9. Who is for 7 to 9?
Lordship, I believe they're not yet represented.
Why? This order is wrong. No, I mean, not order, I mean this submission by the counsel for the petition is wrong. He says that 7 to 9 are sub branches of respondent number 6. Cannot be. Village council cannot be a sub branch of YMA. Oh, right. Office note dated 18/3/26 states that AD card has been duly received from respondents number 7 to 9. However, no one appears for the respondents 7 to 9. So what do we do if they don't come? We issue arrest memo.
If I may be allowed to file my affidavit, because we, on the part of the state, Your Lordship, action has been taken.
What? For action?
Your Lordship, the petitioners have been moved back to their.
They have been moved back.
Yes, Your Lordship, way back in the month of March or something, Your Lordship, if I may, if that
Then-
is, yes, Your Lordship.
Okay, if that is the case,
Yes, Your Lordship, I'm representing the respondent number 1 to 8, and I'm seeking another 2 weeks' time to file my affidavit.
No. Why should you? Yes. What is your issue? What is the issue here? Here, who is for the petitioner?
My lord.
Decide. Yeah.
Petitioners. Assessment has been completed, my lord. This is regarding the, my land has been damaged in connection
According to you, assessment has been completed.
Yes, award has
According
not
to
been
them,
passed. Award has not been passed.
What has already been passed?
No, award.
Why should award under what? Is this an issue of acquisition?
This is issue of acquisition, yes, my lord.
Acquisition
Yes.
or
the-
damages? What?
My land.
It's
actually-
damages.
Damages. So
Yeah,
this,
damages.
Yes,
this
Your Lordship.
pertains to construction of a road, correct?
Yes.
Yes, Your
Yeah,
Lordship.
like-
Why
Was the
didn't-
road built on your land?
Yes, it was damaged, taken.
There's a thing called, Mr. Counsel, I'm asking you whether the road was built on your land.
Yes, my lord.
Yes. Is it true?
Your Lordship, in that regard, I have to take instruction. I have called the
You
department.
see, yes, you see, there are two aspects,
morning.
because the prayer here is for damages.
Yes.
You have not prayed for compensation for land. You have paid for damages. No, let me see.
My lord, the assessment was conducted and the report is available in page number 37. And however, the
Page 37.
the amount has been partially paid.
Amount has been personally paid?
Paid to me, yes, my lord.
So then why are you filing this case?
The award has not been passed and the solicitation interest, everything has been ignored by the authority.
Yes,
So it's-
you are for whom?
Your Lordship, I appear on behalf of my senior CGC for respondent 1, 5, and 6.
CGC. CGC is okay. Where is she, by the way? Where is the CGC?
Your Lordship, she was hospitalized and she was discharged last week, and she is in the process of recovery.
Okay. Okay.
My lord, I would like to apologize. This is not my case. I'm in item number 7. Sorry.
Your Lordship, in
No,
this,
I want to know where the petitioners are, because we I don't know what they want. Madam, I just want one query to be answered. Whether a road was built on the land of the petitioners. That's all.
Yes, I understand
Just because
that.
there was a construction of land and there's a construction of a road and then damage has been caused to the land, that's a different aspect. That is a question of damages. But if a road has been constructed on their land, then the question of compensation comes into play. So,
From the
please,
petition, from the petition, Your Lordship, what we can see is that it's a damages.
that's what it appears to be damages, but then they are
Yes,
asking for
and-
solatium also. I don't understand. That's why I need the petitioners. Right.
The petition, the
where are-
petitioner
where are-
is there. Saiming Thangasilo is the petitioner. I
Saiming
believe that
Thangasilo.
he is in the court.
Is he here?
Yes, my lord.
Huh? You are Simon Thanga?
My lord, I think the course list that I have here, I'm in course list number 7, the WPC 108.
108 is 6, item 6.
Item 6. All right.
Item 6, yes.
I would like to apologize, my lord. There is a bit confusion.
Well, only thing the problem is now, you see, your petition is not very clear. You are asking for damages, crop damage.
My lord, what I prayed in this petition is just the authority to complete the award as per the assessment which has been completed by the authority.
In the assessment, you see the assessment, the NHIDCL, I
This is
think
not, my lord, this is the construction was taken
the
by the
just a minute.
state
PWD
PWD.
department.
the PWD is here. Then, but PWD have not signed.
The
And-
individual assessment is in 38, my lord.
You get your information,
yeah.
madam.
Yes, Your Lordship.
Okay, right. The petitioner claims damages along with solatium and interest, etc., for the damage caused to his land. Ms. Vanesiami, learned counsel for the state government, shall obtain instructions as to whether a road was built on the lands of the petitioners, or if the question pertains only to damages and not compensation. This is the matter when? Give it next week.
After
Give
2
it.
weeks, Your Lordship.
On the inquiry whether the road has been constructed or not.
18, 6th.
Obliged.
Item 7.
Lordship, service report from respondent 2 and 3 are awaited, Lordship.
My Lord, I am appearing for on behalf of my senior, Mr. Keladin Lina, my Lord. And my lord, I'll be filing vacao on behalf of respondent number 2 and 3, my lord.
What is this matter?
Lordship, this is an appeal against order in CMA. And this is basically between matrimonial problems, Lordship. And there was some one LIC policy which was held in the name of my wife. And my wife is now processing surrender of the LIC policy.
So it's in her name.
It's in her name, Lordship.
What right do you have?
Lordship, that was the main challenge before the civil court.
But what right do you have?
Lordship, my ground was that there was prima facie fraud in surrendering process.
Yeah. No. The issue is when the policy is in her name, what is your right to have any say in that policy?
And Lordship, that basically...
Supposing you have a fixed deposit in your name. If you have made a fixed deposit, you want to break the fixed deposit. Can some other person challenge it? Your wife or your children, your father, your mother, grandfather, grand ancestor, can they challenge?
The thing is that, Your Lordship, that policy, in fact, was contributed from my money. And if it is to be surrendered, Your Lordship,
How
the
do you prove
subsequent
that?
effect,
You have accepted it. It's like giving a sweet to a child and saying, you have eaten it. Now it's 3 days. Now you give it back to me. How can you do it?
but at least, Lordship, that is a family property in my interpretation, Lordship. So even if that is surrender, substantial sum of money should be given back to me, Lordship. So that is the main challenge before the civil court also, Lordship. So
I don't. Anyway, we'll fix it for some other day. You want to file something? You want to say something? What?
My lord, in the meantime, I may be allowed to file the objection
Did you file your objection?
in stay application as well as the FAO.
You see, stay and this thing has to be disposed of
Yes.
together. It cannot be disposed of
It
one.
can go together.
You see, let the stay be there.
Status quo is maintained already.
Status
my
quo.
lord. Yes.
So we'll
Let it be like that.
close this. We'll close this. We'll status quo. And this is the thing. This has to be disposed of.
And in that case, I don't think it will be necessary to file objection as well, my lord, because this is an appeal against.
You make up your mind what you want.
Okay, then I'll file. Since I had already been given the time. Chance.
Yes. I don't find any case, basically. But since they want time, we'll give them time.
that's it.
It can be disposed of by tomorrow also, my lord. It's a very simple matter because it is regarding rejection of the injunction application. And he is the nominee only. And Supreme Court's decision is very clear, which is also based by the learned trial court. So long as the policy holder is alive.
Now you have gone. We'll give you time. How much time you want to file?
Only 1 week, my lord.
Okay, right. In the main case, you're right. Mr. Bilara Mehra, learned counsel for the respondent number one is granted a week's time to file written objection. This is the matter on given date, after a week. And then in the IA, you write, in this IA, heard Mr. T. Lal Nusyama and Mr. Bilara Mehra, learned counsel for the respondent number one. Yeah, for?
Respondent number 2 and 3, my lord.
Are you filing anything? No, you're not filing anything.
No, my lord.
Acha, Mr. What is your name?
R.L. Woodfellow, my lord.
Appears for respondent number 2 and 3. In the other order also, you write, On considering that the status quo order has already been passed on 18/5/2026 and that any decision here would affect the the main appeal, the status quo order is confirmed till final disposal of the main appeal. I is accordingly disposed of. Then this, give a date. But I don't.
16th.
How will you do it? Then everyone will cause trouble. Every fixed deposit, your brother will come, your third cousin will come and say, even I contributed money there.
Let us see, Your Lordship. Let us file
I don't find any case, frankly.
Your Lordship.
Item number 8.
The list of dates which you also asked me to prepare.
Have you given them one copy?
No, my lord. They can produce this.
You should follow this habit of making one for the other side also. Yes, just tell me what is the case basically. So there was a you are starting with a supplementary draft award.
Yes, my lord.
Where is the draft award?
It's in the petition, my lord.
It's not in your list of dates. You are starting from the supplementary draft award.
Yes, my lord.
Your list of dates should start from the award.
My lord, those were phase 1, under phase 1. Several persons were given. So far, the present case
so
is
this is
concerned.
under phase 2 or what?
Yes, my lord.
Then you should have made it clear. No, you have now left it
Otherwise,
for
my lord,
imagination.
in my writ petition, I have the detailed list of dates.
Okay, so there was a in the phase 1 there was an award,
Yes, my lord.
and then so that is no problem. That is no problem. Correct?
They were all paid. No
All
problem.
paid.
Yes, my lord.
Then
The remaining, landowners.
then the supplementary draft award was made. Correct?
yes, my lord.
And out here 303 landowners were there.
Yes, my lord.
After the draft award was approved, the pronouncement was made. So this item 1 and 2 are the same.
Yes, my lord.
Item 1 and 2 are the
Yes,
same.
my lord.
So the supplementary award was withdrawn. Or it was decided to withdraw.
Yes, my lord.
Then it was cancelled. Okay, so in the supplementary award, there were 303 people.
303 in total.
And that was cancelled.
That was cancelled.
And then after that, the draft award was issued. Draft award number 1 of 22.
Yes, my lord. In respect of only 138.
138 landowners.
Yes, my lord.
Now, draft award was approved by the state government. So then, okay, another draft award was made
This one of 2026 superseded the one of 2022.
for the same 138 persons or for how many persons?
Only the same 138 persons.
Okay.
For the remaining of them, my lord, if you see the last item number, para number 12, for the remaining claimants, my lord, there was a case, and the Learned Special Court PC Act had already disposed of that case on 26/9/2025, and out of which 2 officials from the district council were convicted, and the remaining landowners were acquitted, but their land passes were cancelled in respect of the remaining apart from the 138.
No, not on that. Draft award 1 of 22 was made for 138
Yes, my
land.
lord. Yes, my lord.
Now, then afterward, the draft award of
One of-
22 was superseded by draft award of 26
Yes, my lord.
and for 138 persons.
Yes, my lord.
What is the difference between the two awards?
There was I have not seen the exact assessment of this one of 2026, but as per the information I received, they have made reassessment due to the multiplication factor.
Huh?
Multiplication factor, which was not.
So there
which
is
was
a difference in the rates.
Yes, my lord.
Is it higher, lower, what?
This one of 2026 will be much higher.
Higher. So you are there in this 1 of 22?
Yes,
and
my lord.
you are there in 1 of 26 also?
Yes, my lord.
Then what is your grievance?
My grievance is, my lord, by the time of filing the writ petition, my lord, this one of 2022 and 26 were not yet made. My basic prayer was to give us compensation in terms of the 2013 Act, and which is accordingly made and not yet finalized.
Accordingly made.
Accordingly made and not yet finalized.
Now it has to be paid, that's all.
Yes, my lord.
So that supplementary award and all that is of no use now. That's
Yes, my
finished.
lord.
Correct. You're not aggrieved with the cancellation of the supplementary award. Are you aggrieved?
That person is not in question now.
That is not a question.
Yes.
So that is not the issue now. So the issue here is that
We
you
should be
should,
paid
you should
our-
be paid as per the 2026 award
Yes, my lord.
under the 2013.
13. Yes,
That's
my lord.
all.
Yes, my lord.
Yeah.
My lord, the case is more complicated than it
Oh,
looks, my lord.
I thought he made it very simple.
The problem is, my lord, there's some overlapping of land with the forest land.
Okay, okay.
There are 3 land holdings in this project corridor. One is forest land, private land holdings, and degraded Jum land.
And
Degraded
Jumland.
Jum
Okay.
land. So
Jumland is
Jum land is forest land according to the Supreme Court.
and Jumland is covered by the Juming regulations. There in Mizoram, there is the Juming regulations.
So for that, on the last occasion, my lord, we have submitted before this honorable court that the forest department may be made a party.
So there is overlapping of land
Yes, my lord.
in terms of the draft award number 26,
Yes,
22 also.
even the latest is my lord.
In 22 also there is. And supplementary draft award is not of any relevance now, correct?
If I may take a lordship to the affidavit filed by the petitioner 11/11/2024, affidavit dated 11/11/2024, wherein I have enclosed the draft award number 1 of 2022.
11 of?
Affidavit dated 11/11/2024.
Yes.
I have enclosed in Annexure 4 the draft award number 1 of 2022, page number 1515. And if your lordship may kindly see page number 1616. It starts, the para starts with forest land. May I read?
Yes.
The total area of forest land reported in the original DPR was 15.2 hectares. However, the Environment Forest Department claimed that since an area of 181 acres originally classified as degraded Jum was included in forest area, and hence the total area of forest land becomes 196.75 hectares. A meeting to identify and settle forest land of 15.24 hectares within land acquired for KMMTTP Road was held under the chairmanship of the Secretary Land Revenue and Settlement Department on 4/2/2021, and the meeting constituted a team of officers under the guidance of the District Collector Longklai to identify 15.24 hectares of forest land, excluding zoom land or degraded zoom land. Pursuant to this, a joint verification for identification of forest land was conducted on 9/2/2021 by the state team of the officers. The finding of the verification team are as follows. 1. Forest land is identified in 2 locations. The first location is at such and such. The other location is at Anchirikon with a stretch of approximately 3.2 kilometers. Third, my lord, the forest land area is identified as 15.24 hectares for which payment of NPV on compensatory afforestation will be made. This shows that, my lord, for the portion of the land which was claimed by the forest as their own land, this NPV and CA is to be paid after making it. The claims of the private individuals were not disturbed by this. It's between, once they make the NPV and CA, they will pay the due to the forest.
What is NPV?
The net present value of the forest land. And the same.
Forest land cannot be taken away.
They're going to pay by the acquiring authority this portion, my lord.
They're going to pay?
Yes, my lord. The portion, these 138 lands were situated beyond the forest land after identification, my lord. And they're willing to pay for this portion after assessing, making the NPV and CA.
No, forest land, you cannot take over forest land. You have got to declare that it is non-forested. It's a reserve forest or what?
The land claimed by the forest is this 15.24 hectares, and for which they're going to make payment for after making the NPV and CA.
I'm not getting where is the problem. Ms.
Moreover,
Linda?
my lord, in various documents of the state, which have been continuously filed in the various affidavits, my lord, it is that, if I may take a lordship to the affidavit filed on 14/5/2024 by the state, 14/5/2024. Additional affidavit dated 14/5/2024.
Yes.
Page number 10. Letter dated 2nd June 2023. This is written by the Secretary of PWD to the MORT. With reference to any continuation of the letter referred to above, which was sent to you by the Chief Engineer Highways, PWD, I am indebted to request you to kindly obtain approval and sanction of the competent authority for the cost of land acquisition, compensation for buildings, standing crops, etc., demarcation of land and mutation fee for construction of new lanes such and such, amounting to rupees so and so only. As you are aware, second para, the issue of payment of land compensation has been pending for considerable period of time due to claims and counterclaims regarding status of land holdings and land ownership. Based on the findings of the SCB, the Honorable Gauhati High Court has directed that payment of compensation should be made in respect of 138 genuine landowners. The state government has also accepted the judgment order of the High Court and has proceeded to implement it by giving approval to the draft award number 1 of 2022 prepared by the district collector in compliance with the direction of the Honorable High Court. Notwithstanding the fact that the issue of forest clearance is yet to be resolved, it is quite certain that there is no other option but to pay the 138 genuine landowners the cost of land acquisition, compensation for buildings, crops, etc. I am therefore requesting to kindly to process the issue and obtain approval and sanction of the competent authority as indicated above, so that the project can finally be completed and the genuine landowners can finally receive their rightful claims after a prolonged delay. My lord, the fact remains that while the draft award 1 of 2022 was made and approved by the state government, no challenge was made by any authority whatsoever before any forum. And as of now, due to
So 122 and 22,
One of 2026.
22 and 26, there's no difference.
except
Only in the rate.
the quantum,
Only in the rate.
yes, my lord.
So 22, there was no challenge to 22.
No challenge, my lord.
Yes, madam. If there is 22 is the same as 26, except for the land value, why are you not paying?
My lord, I'll take a lordship to my affidavit dated 24th of April.
24th of April,
Yes, my lord.
2000?
2024. At page 7, my lord.
Twenty-fourth of April.
24 for yes, 2020.
I don't seem to have 24th of April. There is no 24th April, madam. I've got 24th June.
My lord, it's an additional affidavit filed by the respondent number 5, DC Longklang.
Oh, I got to. I got to.
My lord, this letter dated 30th January 2026 is the letter seeking for approval of the draft award number 1 of 2026 sent by the DC Longklang to the Under Secretarial and Revenue Settlement Department of the Government of Mizoram.
The additional affidavit, but it's reflected in the order dated 30th 4, 2024.
Second copy,
additional
है ना,
affidavit
second
was
copy
filed.
है. No, 14th, don't have to bring everything. 14th April, no, you said?
24.
24 April. No, so it has been sent for approval.
Yes, my lord.
So do we wait for it or what?
That is what I have asked for this. I have not received any outcome of this.
Yes, madam. What about this 30th January 2020?
My lord, they have issued this this letter again, my lord. However, my lord, I think Forest Department needs to be made a party in this case.
No, why? Why you want to delay the matter?
Because there, no, my lord, there is a NGT order also, my lord, by the Supreme Court.
There's an NGT order.
Yes, my lord.
You can always file an application. There's no bar for you to make an application. But why should he impede? So tell us why should the
Well,
Forest
the-
Department be involved?
The state government has written
This
letter
is
many
from
times.
this who? Our copy. What is there? Yes, which para? 24th April.
my lord, page 7. This is para H of the additional affidavit. Para
Page
7.
7.
Page 7, yes, my lord.
No, madam, the issue is this. When the award of 22 has already been approved by the government, and the award of 26 is only a reiteration of 22, except with the minor change of with regard to enhancement of the compensation amount. What remains? What is to be decided?
My lord, the forest will have some say in this matter, my lord. There are some,
You should have taken that before.
my lord, I have, even this honorable court has given a direction to impede the forest department.
Oh, where?
No, my lord.
8/9/2025.
Mr. K. Rowland. Who's K. Rowland?
One of the
Petitioners. Acha, it says like this. The learned additional AG submits that on perusal of the case, it appears that the Forest Department is a necessary party in the instant writ petition. Mr. K. Rowland, learned counsel for the petition, has prayed for time to file an impleadment application impleading the Forest Department. Mr. Victor, is he a junior?
Yes, my lord.
So he has prayed for time for impleading the Forest Department. But I don't know. I do not know the use of making the Forest Department a party.
So far, the state respondents are concerned, my lord. On their own documents, my lord, they have also take steps for payment of compensation to the petitioners by writing letters to the court.
My lord, if I may, I have spoken to the DC Longkai also. I asked him what is the development. The answer is the same, my lord. They said the issue remains with the forest department, even though they have issued this 2026.
Then why did you approve one of
That's why, my lord,
2022?
that's why. So no developments because of that issue. I don't think any development will come out.
Okay, you take this decision within within 10 days. Failing which this case shall be decided on its merit. There's nothing here. Your junior has said that he's going to take time to implead. So you're not going to implead. Are you going to implead or not?
No, my
going to
lord.
impleed?
No, my lord.
No.
I do not find any necessity in impleading the state.
Then you should have verified. You should have clarified this order on the next date. You should have
Yes,
said
my
that
lord.
we are not filing. Okay, right. Heard Mr. Victor L. Rath, the learned counsel for the petition. Also heard Ms. Linda L. Fambol, additional AG. And anybody else? And Mr.
Zero.
I appear on behalf of my senior
Their
CGC.
name,
Dear Ming Tanga.
Dear Ming Thanga, on behalf of the learned CGC. The matter pertains to non-payment of compensation to the petitioners for acquisition of land pertaining to the construction of a new two-lane highway from National Highway 54 near the Longklai Indo-Myanmar border in Mizoram, comma, to support the Kaladan multimodal transit transport project, bracket KMMTTP, bracket close, in phase A of SARDP-NE. Correct?
Yes, my lord.
Full stop. The petition, next para. The petitioner's case is that in respect of the construction to be carried out for the KMMTTP, an award had been made in the first phase for acquisition of land under the Land Acquisition Act 1894, comma, wherein all the landholders were paid their compensation amount. Next. In the second phase, for acquisition of land, a supplementary award number 1 of 2016, award number 1 of 2016 was made and pronounced on 7/4/2017 in relation to 303 landowners. Full stop. However, due to there being some discrepancies regarding fraudulent claims, comma, supplementary award number 1 of 2016 was cancelled on 4/7/2019. Full stop. Being aggrieved by the cancellation of the supplementary award number 1 of 2016, WPC number 90 of 2019 was filed with regard to the decision to cancel, with regard to the decision and the ultimate cancellation of supplementary draft award number 1 of 2016. During the proceedings of during the proceedings of WPC number 90 of 2019, comma, draft award number 1 of 2020 was made by the respondents in respect of 138 landowners in terms of the RFC TLA RR Act, 2030, wherein the names of the petitioners herein were mentioned for payment of compensation, comma, for acquisition of their lands for the KMMTTP. The draft award number 1 of 2022 was approved by the government of Mizoram on 14/7/20. The approval of the draft award number was conveyed by the office of the DC Longklai to the EPWD Multimodal Project Division on 14/7/22. However, draft award number 1 of 22 was superseded by another draft award number 1 of 2026 against the same 138 landowners mentioned in draft award number 1 of 2022. Full stop. The only difference between draft award number 1 of 2022 and draft award number 1 of 2026 was that the rate of compensation had been enhanced in draft award number 1 of 2026. Full stop. Next paragraph. The District Collector, Longklai District, via letter number R full stop 12017/33/2024 DC bracket LTI. Thereafter wrote a letter dated, the District Collector wrote letter number so dated 31/26 to the Under Secretary to the Government of Mizoram, Land Revenue and Settlement Department, Aizor, stating that he was submitting the draft award number 2026 pertaining to the revised slash reassessment of draft award number 1 of 2022 in connection with acquisition of land for construction of the KMM-TTP road. For information, amounting to rupees so and so, inclusive of so and so, lekha hai normal. For information and to convey approval for the same. Next para. The learned counsel for the petitioner submits that no decision has been taken by the government to the letter dated 30/01/26 issued by the District Collector, Longklai. So you are okay with 22 also?
Yes, my lord.
Anna?
Yes, my lord.
You don't need 26. Do you need 26?
Yes, my lord.
You want 26 or 22? Which one?
26, if it is the latest, my lord.
That
And
has
if
to
it
be
is
that
already
is
under
subject to
process.
approval. No, that I cannot approve. This High Court cannot approve the rate. That is the duty of the government.
Whichever is approved as per law, under the Act of 2013.
So, okay. The other one, was it approved as per the 2013 Act?
The first one.
22?
Yes, my lord. 13.
13?
Yes, my lord.
Yes, why don't you pay under 13 then? Under 22? Why did you cancel this 22 by 26? Why did you supersede it? On what ground? According to him, it's only enhancement of the compensation amount, the rate.
It's only with regard to the.
If that's the only case, then you pay him 22. What have I said? Where does it say that under the 2013 Act?
My lord. Para page number 15 of my affidavit, 11/11/2024. Affidavit dated 11/11/2024.
Paragraph? Page?
Page number 15, 15 onwards, the draft award 1 of 2022. And from page number 18, 17 onwards, my lord, page number 17 onwards, it can be seen that it is under the Act of
No, no,
2013.
where is the government approval?
Government approval. Page number 24. Letter dated 7th July 2022.
Yes, madam. You see, one thing I don't understand is that he under 22 you have to pay because government approval is there. Government approval is there for 2022. And the rate there is 60 crores. By 26, you are willing to pay 145 crores. Why? Why you so? Why I thought government was not having any money. What is going on?
It's very difficult to explain, my lord. The forest department has contacted me directly to include them as a party.
Then you file an
And the
application.
DC has made his own calculations. So it's
Who has made the? Oh, see,
DC.
but
DC
government has
law.
approved.
So it's a difficult situation for me also, my lord.
Then you call a meeting, madam. You are like
That's what, my lord. To call a meeting, the forest is not even a party in this case. And for a consolidated pairwise
Madam,
comments also, my lord, they are not
You see,
included.
there is no problem for you to make an application. Why do you want only the government, the private
All
litigants
right,
to
my lord,
make
then we
application?
can file an application.
You file an
to-
application, then, but
yes.
why don't you pay this 22? The issue is very small. There's nothing much. Where are we? Right. On the other hand, the learned edition lady submits that the forest department is a necessary party and she would like to file an application for impeding them. On hearing the parties, it is surprising to see that compensation in terms of draft award number 1 of 2022 has not been made. Even though the same has been approved by the government at the rate of rupees 60, 81, 95, 531. Page 24, I know, of the affidavit dated 11/11/24. On the other hand, no, full stop. The above being said, it is surprising to learn that a new draft award 1 of 26 has been made by the government, has been made by the concerned district collector at the rate of which he wants approved by the government, amounting to rupees 1, 47, 85, 64, 184.04. No justification has been given by the district collector Longklai as to why the compensation amount of rupees 60.81 crores approximate should now be enhanced to 147.85 crores approximate. within a matter of 4 years. No, within a matter of 3.5 years. The above being said, the additional AG is allowed. How much time?
2 weeks, my lord.
Filing an application
My lord, I can file it within a week, yes.
is granted 10 days time to file an application impeding the forest department. Oh, wow. You see, Mr. Victor, one
Yes, Your
thing.
Honourship.
I can understand 22, okay. But why suddenly the district collector 60 crore, suddenly 145? 80 crore addition, on what basis? The state respondents are directed to make an inquiry with the district collector Longklai as to why he has suddenly increased the compensation amount in draft award number 1 of 2026 to rupees 147, 85, 64, 185.04, when the draft award number 1 of 2022 only required payment of rupees 60.81 crores approximate. List the matter. Revert it after 10 days. Look at the at Panira on top kada.
25th of June.
Be obliged.
You give them as per 22. It's very easy.
Item number 9.
And item. Yes. Who for the petitioner?
My lord, I
He has
appeal for
not
the
taken steps for Kala. I thought they are not represented.
My lord, because they were impleted last week,
So?
on Friday.
So?
My lord, we are taking steps presently, my lord.
It
My
says
junior
within 4 days, Mr. Counsel. Within 4 days.
Within 4 days. My lord, my junior is, it was on Friday, my lord, if I'm not
So,
mistaken.
yes.
So Saturday, Sunday, my lord, within 4 days, so Monday.
Your Lordship,
Fourth was on Thursday.
My lord, I was not here. I'm so sorry, my lord. I was not.
Your Lordship, today was fixed for
That,
submission of the
that,
confidential papers from JICA. So
No,
as to
not submission of contract. It was for their prayer to be dropped as a party.
Yes, yes, correct.
What is this?
Your Lordship, I am there appearing virtually.
Ah, Yes.
To submit my arguments. So whenever you are ready, I can start, Your Lordship.
Who is giving these judgments?
My lord, this is not an appeal, this is a writ petition, my lord.
No, who has given these
Ocha,
citations?
JICA, Your Lordship.
JICA. Yes, you can start.
Thank you, Your Lordship. Your Lordship, as we filed the deletion application, I would like to make few points. Number one, as I would like to inform you what is JICA in India and what they are doing in India, and more specifically what they are doing in the northeast region in India. Your Lordship, in fact, if there is a brochure I had given to my counsel, but there was some printing problem. But I am just mentioning, and she will refer the document on the mobile only. See, JICA is an international agency of the government of Japan. They contribute to the development of emerging India by providing the official development assistance through loans, and sign the loan agreement with the government of India, which is Union of India in the present case also, respondent number 1. When they signed the agreement, they made as part of their worldwide policy with all the world, wherever they tender their loan and give the assistance, they made this part and parcel of the JICA guidelines, which is also in this case also was made as JICA guidelines part of this. But before that, Your Lordship, I would like to point out that in fact this loan JICA started giving to India since 1958, almost 65 years. They are working with the development of the country along with the government of India, and with northern eastern also, Your Lordship, they have contributed almost more than 25,345 crores in the various region where they are working, supporting the projects of road transport, health, water sanitation, forestry, energy sector, and which is amounting to, I mentioned about this, for 25,345. So this is the government is taking help from JICA, and we are here not only for northern eastern area. In fact, we have worked for almost worldwide within India 336 projects and amounting to 8,339 billion, and these figures, Your Lordship, I am mentioning since December 2024, and this number has increased now as per the current rates. Now, Your Lordship, you have a JICA guidelines with you, which is made part and parcel of this project also. Your Lordship, I take your reference to page number 15, article 2.6, Your Lordship.
Page number 15
Your
of
Lordship,
what?
it will be in the sealed
Page
envelope.
number 15 of
It
JICA
is-
guidelines.
We have submitted in a sealed envelope.
JICA guidelines, Your Lordship.
Yes.
It's April 2010 document, Your Lordship, which was made part of this loan agreement, and I am taking your attention to page 15, clause 2.6.
Yes.
Your Lordship, this article says, in principle, JICA confirms that project meets the requirement for environmental and social considerations stated in the guidelines in the following ways. JICA confirms that projects comply with the law or the standard relating to environment and local community in the central and local government of host countries. It is also confirmed that project conforms to those government policy and plan on the government and the local communities. Your Lordship, I take your attention to the second paragraph in the middle of fourth line, when JICA recognizes that, the same page, Your Lordship.
Yes.
You have it? In fact, para 3, but I was leaving 3 lines before and mentioning when JICA You have it, Your Lordship?
Yes, yes.
Recognizes that the law regulation relating to environmental and social consideration of the projects are significantly inferior to the aforesaid standard and good practice. JICA encourage project proponents, which is government here, etc., including local governments, to take more appropriate step through a series of dialogues in which JICA clarifies the background and the reason of the inferior regulation and take measure to mitigate the adverse impact when necessary. Your Lordship, fifth line, JICA discloses information with reference to the relevant law of the project proponent, etc., and for the government of Japan. So, Your Lordship, this very clearly clarifies that it is the law of India will be applicable. Even if it is inferior, my guidelines, government has to look into the current law, which is local laws available. I again further take your attention, Your Lordship, page number 29 of this document.
No, this clause 5 says what?
It's not, Your Lordship, I was reading the same 2.6 paragraph only. Now I am reading the next clause.
You were reading, what was the last sentence you read?
I read this 2.6 paragraph 5.
Yes.
JICA discloses information in reference to the relevant law of project proponent, etc., and of Japan, law of the government of Japan.
No, so it's the relevant laws of project proponents.
Project proponent is Indian government, Your Lordship.
And then?
Your Lordship, now I take your attention to page number 29, Article 4.
Yes.
Your Lordship, the heading says compliance with law, standard and plan. Project must comply with the law, ordinance and standard related to environmental and social consideration established by the government that has jurisdiction over the project site, including both national and local government. They must also conform to the government environmental and social consideration policy and plan of the government that have such jurisdiction. Project must in principle be undertaken outside the protected area that are specifically designated by law or ordinance for the conservation of nature and cultural heritage. So, Your Lordship, in nowhere I am saying my guidelines are supreme, my guidelines needs to be followed. As per the writ petitioner, wherever they have mentioned, nowhere I was involved
But this
in any
says,
form
but
of
this
the
says
above.
that projects must comply with the laws, ordinances and standards related to
Yes.
environmental and social considerations, nothing else.
Yes, Your Lordship, here the environmental and social consideration what writ petitioner has raised, they are saying the award given by them is as per the JICA guidelines, which is inferior, and they should have been given as per the...
No, but so you see, monetary considerations do not come with it, this environmental and social considerations.
Yes, Your Lordship, I am taking now your attention to the another document to which this document is part and parcel of this. You have a loan agreement. My learned counsel has given you the one document which says loan agreement.
Yes.
This is the document, if you see, Your Lordship, it has been agreed between, for this project, Japan International Cooperation Agency and President of India of March 31, 2017. Your Lordship, in this, if you see the second page, which is just a table of contents,
Yes.
it talks about the allocation. This refers to, Your Lordship, Schedule 2. After the terms and conditions,
Yes.
it talks about Schedule 2, which is allocation of proceed of loan. So, in fact, although the first page talks about, if you take the first page, the loan amount, it talks about, it is 67,170,000,000 which is approximately 39 crore for this project, and 95 project payment, this project has already been completed. But I take your attention to Schedule 2. Your Lordship, end of the agreement, it is actually after 9 page is the agreement. After that it is unnumbered. If you see page number, actually after 2 pages only we have Schedule 2.
Yes.
Your Lordship, Schedule 2 says allocation of proceeds of loan. So it talks about the total consideration also, how much is the loan amount. It says it will be category, amount of loan allocated, percentage of the expenditure to be financed. So any construction work, procurement of goods, services, it will be 100% procured, and amount is also mentioned in Japanese yen. Any consultancy has to be also 100% expenditure, and any contingency also. But if you see the note below, item not eligible for financing are shown below. And if you see, your Lordship, item number D, it is compensation.
Purchase of land and other real property compensation.
Yes. So, your Lordship, this order, we were impleaded on the presumption by the petitioner that we are the funding agency and our, in fact, presence is necessary. But, your Lordship, we are funding the project, but we are not funding the purchase of land or any compensation.
That has nothing to do with you.
Yes, nothing to do with me. Even if this writ petition is in success or dismissed, both the case, it does not harm me, my status, what I am doing. But keeping in mind in this litigation for a long time, definitely it discourage my client to be in India and unnecessarily.
No, we don't want you to be discouraged. But I don't think you leave also.
Thank you.
Not
Your
for
Lordship.
this, not for this one small contract work.
Yeah. So, your Lordship.
But why do the government say that the compensation will be paid as per the JICA matrix? What is this JICA matrix?
See, your Lordship, as I read JICA guidelines relevant paragraph, see, lot of places where social and economic and environment consideration has not looked into and they want to pay less. In fact, but our guidelines is that they have made as a standard which is more specific and more beneficial, keeping in mind worldwide. And this is based, in fact, if I read even the JICA guidelines itself, make a reference of World Bank policies and in synergy with other Asian Development Bank, etc. So they want all over the world. It is nothing to do with only India. This JICA guidelines is applicable worldwide. So some countries, they may have inferior laws than what JICA guidelines is put in. And here the dispute is, government says, which is nothing to do with me, but I'm just making this as information for you, your Lordship. Government of state says they have paid more beneficially, keeping in mind JICA guidelines. They were supposed to pay as per the first schedule, but petitioners are saying no, they are not supposed to receive the compensation under the first schedule, but they are supposed to receive under the third schedule of 2013 Act. So, your Lordship, this law has to be proved and the facts has to be proved by petitioner and the government, who's the specifically executive agencies. And in fact, so that's actually, I rest my case. If you want any clarification, I can give you other reference how I will be prejudiced. In fact, their writ petitioner, in the writ also, nowhere the documents where they have made this, that first award was accepted, second award was rejected, JICA guidelines. I was never involved. No document is copied to me for evaluation of compensation or payment of compensation. It was all done by the government. But because I have signed the loan agreement as part of compliances, they were providing me all the documents. And state of Mizoram, as per our information, they have in the pleadings also the what writ petitioners are saying, and they are also mentioning in their counter that they have paid as which is more beneficial keeping in mind JICA guidelines. So we are nowhere can define what is the law applicable right now. It is your lordship, it is your prerogative to decide who's right, who's not, what compensation needs to be paid to the correct people, to the petitioners.
Yes.
My lord, the reason why JICA has continued to remain in this writ petition, my
Huh?
lord, the reason why they have continued to remain in this writ petition, my lord, on 7/4/2026, this IA was taken up for disposal, my lord. On 7/4/2026, my lord, an order was passed, and in that order, my lord, it is specifically reflected, my lord, at page number 2. During, your lordship will see, during the course of deliberation, a consensus has been arrived at by the council for the parties that the entire writ petition can be taken up for disposal on a convenient date, preparing an end to the litigation itself. So now, my lord, the reason why they have continued to remain is because this court, my lord, according to this court, they should remain in this writ petition. They can make the same submissions during the final hearing. We are not per se aggrieved by JICA. In fact, my lord, what we are claiming is that we are claiming that this compensation should not be paid as per the JICA guidelines. It should be paid as per the 2013 Act. And so, my lord, the dispute per se is not against JICA. The only reason they have continued to remain in this writ petition is, my lord, for them to give their point during the final hearing. That's all, my lord. And this entire submission, my lord.
So the submission that they have said now
Yes.
can be recorded here.
Yes, we have no objection, my lord. It can be recorded.
Then what is the requirement of them being here?
Absolutely nothing, my lord. We can.
Yes,
we can
the
do that.
government, who is for the government?
Your lordship, in fact, I rely on the same.
Yes.
With regards
Yes.
to the striking out of JICA, the state have not felt any objection.
That is all right. Do you have any objection to JICA being struck off as a party? Madam, that's not the issue, whether you have filed or not. We want to know what you think. It's not the, you see, at the end of the day, you should also apply your own grace sense.
As per order dated 9/12/2024, this court had observed that since JICA is the funding agency,
9/4/2020?
9/12/2024.
9/12.
Since JICA is the funding agency,
9/12 only talks about issuing notice,
no, your lordship,
amended cost title and issue notice, that's all. So you implemented them.
We implemented them.
Why?
My lord, because this court initially had made an observation, my lord, that JICA would be a necessary party. And so, my lord, we had filed an implement application. So they got impleted. And then, my lord, one other thing also, the NHIDCL, when they had filed their affidavit, my lord, they had put the entire blame on JICA. The reason they said, my lord, this was made as per the JICA guideline. According to the
There is
NHIDCL.
nothing, then they have got to show what is the JICA guidelines.
Yes.
Have they shown you what the
No,
JICA guidelines
they have not
are?
annexed anything. But that's their
Then-
statement in the affidavit, my
Just
lord.
because supposing they say that orangutan is actually a crocodile, will you believe it?
Not because of that reason, my lord.
So
but the,
it has to be justified.
Yes.
No? You cannot take everything as its face value. At least not in court.
my lord, if these submissions are reflected, we have absolutely no objection, my lord.
Mr. Saikia, you are here in this matter.
Lordship, madam. For NHIDCL, madam.
For NHIDCL.
For NHIDCL, madam.
Okay, yes. So you are the important one. Yes,
we
you
have
are not. Who is to pay the compensation amount?
My lord, it is the government, my lord, central government, or for that purpose, my lord, the NHIDCL is the executing agency, my lord.
Yes.
But compensation would be paid by the government of India.
So JICA has nothing to do with this.
No, JICA in fact has an agreement with the government of India for providing this funding.
Correct, only
And-
funding.
And they have certain conditions with regard to the road project, saying that if anyone is displaced or any affected family are there, you have to provide these things. Sell land for land, or like some other benefits, annuity benefits, etc. Something like that. These conditions are there. So the state government has issued the notification, and they have also prepared a RNR, and they have prepared under the State Act as well as under the 2013 Act. Now they have forwarded the 2013 Act. Then we said no, it has to be under the JICA metrics, because basic funding was done as per those terms
But
and
then
conditions.
you show me why how JICA
Yes,
is
yes,
responsible.
Here, what happened, there's the study report shows that the JICA matrix is more beneficial than the RNR under the 2013.
What is the JICA matrix? Show us the JICA matrix.
In the
you are
affidavit-
saying you are saying JICA matrix, JICA guidelines, JICA. Show us how you are going to use the money, the grant given by them, the loan given by them for compensating landowners. Where is that?
This is the study report. In my affidavit, I have mentioned.
No. You see, more than the study report, you have got to show us in the agreement signed between the government of India and JICA that the loan amount disbursed by them can be used for compensation. That is the long and short of it, nothing else.
My lord, that is an admitted position perhaps, my lord, but only thing is that whether, my lord, the benefit under the JICA
Admitted, what
matrix
do you mean admitted position? What do you mean by admitted? What do you mean? Admitted position, what admitted position?
My
It
lord,
is an
the
admitted
JICA
position that JICA will not pay the compensation amount. Is it that
No,
admitted?
not that, my lord.
Or is
No,
it
my
the
lord,
admitted
they are-
position
my
that JICA will pay?
No,
Which one?
their conditions are only with my lord, up to funding.
Funding the
Then
project,
thereafter-
correct?
Then thereafter, if the state law, my lord, prescribes a better benefit, obviously, my lord, the state act or the act, whichever applicable, under that compensation has to be paid.
Correct.
It cannot violate the, my lord, local
correct.
laws or land
Mr.
laws.
Saikya, one thing. We are all in agreement on that point that the state law applicable for acquisition will apply, correct?
Lodge.
Now, the issue is whether you can use JICA money, the loan amount, for paying compensation. That is the issue.
No, this is the entire amount is for the construction of the road project.
Correct. So, if it is for the road construction, nothing is left for compensation. If the entire amount is left for road construction, it implies that there is nothing left for compensation. I don't know how you interpret.
No, amount is there. Amount is there. In fact, my lord, as per the my lord, JICA guidelines, my lord, the
Show me the
RNR was
JICA
prepared.
guidelines where it says the amount is there.
My lord, as of my lord, right now, my lord,
No.
the
You see,
entire document is
no.
not there. I can on the next date I can my lord, perhaps place, my lord.
You see, that is the long and short of it. What Madam Sharna,
Yeah.
Ms. Savita has said, is that the loan amount cannot be used for compensation, and has shown me the agreement executed by the government of India and JICA. Now, if you have got some other agreement beyond which is not to their knowledge and to the government of India, that's you'll have to show us. Unless you say that what she has got it's not a correct document or not, it's not complete.
Well, I have to, my lord, inquire about it, my lord, because I do not have myself the entire, my lord, the guidelines as such, my lord, but the study report under which the RNR was prepared.
No,
Those
no, I'm
documents
not on
are
this.
there.
Please, the study, leave the study report aside. There can be 1,001 study reports. The issue is you're bound, the government is bound with JICA on the basis of an agreement, not on the basis of some study report. Let us have the agreement. And does the agreement require the loan amount to be used for paying compensation? That's the issue.
Yes, my lord. That entire guideline will reveal, my lord.
Huh?
The guideline would reveal, my lord.
The agreement will agree, not the guideline. The agreement will show that. You have to show you have got to show me that. No,
Yes,
you
yes,
cannot. You see, you cannot. You are trying to basically pass the buck. Because the issue is that the thing is that you are working under the government of India. Now, if you want, what is the, just a minute. I can hear you just now and I can dispose of this petition also, not a problem. What is the, just a minute. Yes, your case is that your lands have been acquired, correct?
Correct.
Have been acquired, but you have been given the compensation not as per the 2013 Act.
Yes, my lord. No, we are dealing with resettlement and rehabilitation, my lord.
Okay.
Lands were acquired, then subsequent to this, under the National Highways Act. Now, my lord, Section 105 of the 2013 Act, my lord, allows that an order can be passed by the government saying that rehabilitation and resettlement will be applicable to National Highways Act. So because of this reason, my lord, after compensations were disbursed, now to the displaced persons, my lord, a resettlement and rehabilitation award was made, and this was made as per the 2013 Act. Now this 2013 Act was sent to the central government for approval, my lord. And now what happened was, in the central government, they said that the 2013 Act is not applicable and the JICA guidelines will become applicable. They said.
The central government said that?
The central government, in the sense, my lord, let me see, my lord. Sorry.
Respondent number 1.
Huh?
The respondent number 1, my lord.
Respondent number 1 is who? NHIDCL?
National, yes, NHIDCL, my lord. They said, my lord, the JICA guidelines would become applicable. At page 227, my lord. And now, because of this reason, they made another award as per the JICA guidelines entitlement, my lord. And we are challenging this, my lord, saying that since the 2013 Act exists, we have to be paid as per the statute 2013 and not as per the JICA.
You have been paid as per the 2013 Act, correct? Not paid.
We have not been paid.
Not 1 rupee also.
We don't want the, my lord, sorry? I'm sorry, my lord.
You have not been paid any money.
They have been paid money, but the money has been received on, my lord, on protest.
Okay.
On protest. So, so now what we are challenging is, my lord, this money that they have, the new award we are challenging, my lord, that they have made as per the JICA guidelines.
New award? How about there has to be an old award? There's an old award.
The old award is as per the 2013, which was not yet approved.
Approved by whom?
It was sent to the central government, my lord. And if you lordship, it's at page 227, my lord. Central government had said, my lord, that, my lord, first at 203.
No, so what is the difference in the compensation amount between?
My lord, there's a difference of around 5 crores. The total is around the difference is around 5 crores. 2013, my lord, around 8 crores. JICA guidelines around 3 crores. So this is for rehabilitation.
JICA guidelines? Where is the JICA guidelines?
I mean, my lord, they have only provided 1 page of the JICA guidelines, my lord, and this was part of the letter. This is at page number 2.
Where is the JICA guidelines?
My lord,
Which page?
231.
Your Lordship, I have given you the copy. This is a public document, and JICA guidelines only talks about which law will be applicable, which we have read, Your Lordship, 2.6 and Article 4. I have read the first document, Your Lordship. This is the complete JICA guidelines, and this document, in fact, is in the public domain. It is on the JICA's website also, because it is applicable on all the project sponsored by, funded by JICA. So matrix evaluation, how it has been done, with this presumption that it is more beneficial. Whether it was more beneficial, or because the base they are saying the law is applicable is the difference. Government says there is some other schedule will be applicable. They are saying 2013 third schedule will be applicable. It is the government and the petitioner has to decide and prove before the court. And I am not saying you please take my guidelines only, even if it is inferior. Even if it is inferior and they are entitled by 2013 Act, it is the government to take care of this, as I shown you my agreement.
How do you calculate as per the JICA guidelines? Just show me where have they calculated?
So this one, my lord, this new award, which starts from page number 238.
238.
38.
Yes.
My lord, this says on the top calculation sheet of rehabilitation and resettlement as per JICA entitlement metrics. Now this JICA entitlement metrics, my lord, is at page number 231. My lord. Which is supposed to be part of the JICA guidelines. The reason we say this, my lord, is because
231.
231, my lord. This is
So
the.
where is this? I do not find this anywhere. Yes, this page 231 of the writ petition, Mr. P.J. Saikia, where is it? Page 231 of the writ petition. Where is this in the JICA guidelines?
Your Lordship, this has been calculated entitlement matrix. It is not a JICA guidelines. How it has been calculated, it is nothing to do with me.
Okay. This page 231 of the writ petition has nothing to do with you.
It says that, Your Lordship, it is JICA's entitlement matrix calculated as per JICA guidelines, but how it was calculated, who has been calculated, I am not aware, because I am not part of the evaluation. Whatever is given to me as a representation that this is to be given because it is more beneficial, I approve it. It is only for my information. I have nothing to do with this. So I am not aware of any such document, because this is not as part of the JICA guidelines. This appears to have been prepared on behalf of JICA guidelines, which I am not aware, Your Lordship. How this document was procured by the petitioner, or what NDA, my learned counsel is given this benefit that whether this document is correct or not, I have no idea, Your Lordship. I have not been given this document by my client.
Now, my lord, what happened? Lordship will
Yes, from you also. From where did you get this document?
No, I'll tell you, Your Lordship. My lord, 203 was the letter the Mizoram government had sent to the Union of India about the previous award, my lord. They had
about the previous?
The original award of 2013. There were two awards, my lord. 2013 award and the other award under the JICA guidelines. Now, 2013 award was made by once the 2013 award was made, my lord, the Commissioner of Rehabilitation and Resettlement, Secretary of Government of Mizoram, my lord, had sent a letter to the Secretary, Ministry of Road Transport and Highways, my lord. This is at page number 203 of the writ petition.
Yes.
Now, this award made under 2013, my lord, was sent to the Secretary of the Union of India, my lord. Now, once it was sent, my lord, this letter was forwarded along with the draft award, my lord, and at page number 229, Lordship will see. (229). This was a letter between the
NHIDCL.
Yes, this was a letter sent, yes, by the NHIDCL to the Commissioner of Rehabilitation and Resettlement, my lord. It says like this. Please refer to the subject cited above and letters under reference addressed to the Secretary RT&H, which the draft Rehabilitation and Resettlement R&R awards of 5 districts in Aizawl, Serchhip, Lunglei, Longklai and Nathial out of total 6 districts have been submitted to Ministry of Road Transport and Highways. The R&R awards have been prepared as per 2nd and 3rd schedule of the RFCTLAR Act 2013, which is not applicable in the instant case as the project is linear in nature and funded by JICA. In this regard, it is intimated that RAP report was finalized by JICA. As per says RAP report, my lord.
What is RAP?
Now, this RAP report, my lord, my humble understanding.
What is RAP?
My lord, will come to page number 235.
What is RAP?
My lord, this RAP, this is the, they have used RAP report the entire time, my lord.
So you don't know what it means?
My lord, I don't
you
know.
have not asked them also what it means. Yes, what is
It
RAP?
is resettlement of action plan.
Resettlement of action plan.
Yes.
Resettlement
Of action plan, RAP. report.
Resettlement of action plan. So next time, please understand what you are what you're dealing with.
Yes.
Your Lordship,
Now,
if
this-
the letter which
this
my
RAP
Yes, madam.
with the letters which my learned counsel has referred right now, if you see, these are between the government and between the
NHIDCL,
two governments.
yes.
Nothing. I was not copied to
Now,
these letters.
but my lord, that part we have no dispute, my lord. Now the RAP report was mentioned here. Now, if your lordship will come to page number 235. 235.
No, madam, I think your presence seems to be necessary because NHIDCL seems to, it appears to be trying to wriggle out of its commitment, and you are the check that ensures that the JICA matrix has not been applied. That's the only thing.
Your Lordship, if I may request, maybe because the council here said that they are not aware of the document and they may not have a proper instruction. Just with my
Yes,
presentation,
yes.
Your Lordship, maybe you can take an instruction and we can pass it over this matter this week. You are here this week also. You pass it over for Thursday or Friday. Let him take the instruction whether we are funding anything or not, because now Kala has already been implemented. That means I am going to be there for another years.
Correct.
My counsel has.
No, we'll dispose it off. I think all the pleadings are there.
My lord, we have absolutely no objection to your lordship sitting or anyone else, my lord. But the thing is, let me tell your lordship, today we took steps upon Kala, my lord. So now I'm not sure whether this will be completed. We have absolutely no objection.
Otherwise we could have disposed of
My
the
lord,
matter.
we-
I think everything is pretty clear.
Yes.
I think, Mr. Saikia,
Lodge.
there is nothing to show that other than the 2013 Act, anything else can be used for acquiring land in the state of Mizoram, especially with the division bench judgment of this court.
Lodge.
So, you applying JICA matrix,
Lodge.
supposing there is a clash between JICA guidelines and the 2013 Act, which will prevail?
Yes. The 2013 Act will prevail, but there is also one provision, my lord, section 108 perhaps, my lord, which says any better R&R other than the, my lord, 2013 Act can be opted by the, my lord,
But
claimants.
that is your, you have to show us that. It is
Lodge.
your duty.
Now in the affidavit we have given certain comparison how JICA matrix is beneficial more than the 2013 Act, RRA under 2013. That was the preparation. And the detail, my lord.
But where is the JICA matrix? Where is the guideline?
Well, that,
because the one that has been given to me does not show how it is beneficial. Where are you going to resettle them? Where is the resettlement plan made?
No, my lord, here another plea we have taken, my lord, this acquisition process is, my lord, linear in, my lord, nature. So there is no, my lord, rehabilitation of, my lord, dislocation or, my lord, displaced family.
Correct.
So therefore only everything can be done in terms of money.
Correct, it can be done in terms of the 2013 Act also. What will apply there will apply here also.
Exactly.
Basically, what you are trying to say is that the resettlement issue will not apply to this case. Correct.
Because
Yes. No, supposing you are correct.
no, my lord,
So-
here, my lord, what ultimately my argument would be in the merit, my lord, they are, my lord, trying to compare the, my lord, RNR under the JICA matrix and the, my lord, RNR under the 2013 Act. And the 2013 Act reflects, my lord, better amount than the, my lord, the amount which was assigned under the, my lord, application of JICA matrix.
No,
But do-
Mr. Counsel, one thing. With regard to land compensation, 300A, 2013 Act, the money value, wherever, you see, it has to be given as per the 2013 Act. That is very clear. Your agreement, if it's better than the 2013 Act, that's a different issue. Then you'll have to pay maybe as per the contract, as per the agreement made. But when the law provides that land has to be acquired in terms of the Act, you cannot now give a lesser value or lesser amount. That's very
Exactly, my lord. My lord, our contention is the amount, my lord, granted under the.
Anyway, what we'll do is, for the time being, I think we'll delete them from the party. What is the requirement? Why do you need them? You don't need them. Because it's not your writ petition anyway, unless you want to implead them. You want them to be parties here? Mr. Saikia?
My lord, it is the writ petitioner who has filed an application for plea. I don't want the JICA to be a party.
I think you won't want JICA to be represented. They are going to put a full stop every time you.
No, not at all, my lord. Not at all, my lord. We are not, my lord, doing anything, my lord, which goes against JICA or my lord, government of India, my lord, or something like that. But our only contention is that the calculation of the compensation, my lord, computed under the JICA matrix is better than the.
But you have got to show us. You have got to show us where is the JICA guidelines. How are you going to calculate? Where is that?
Yes, my
it's
lord,
very easy to
that's
say JICA without showing us what is the theory or the guidelines that they are supposed to follow. Where is that? Not
Yes,
one.
my lord, I'll be producing the entire document, but for a moment, my lord, in the affidavit which we have filed, we have, my lord, annexed, my lord, the policy and the legal framework. There, page 15, your lordship may see the key gap between, my lord, 2013 Act and the JICA guidelines.
Your Lordship, these are the contention of the petitioner. My
correct.
counsel is mentioning that if it is more beneficial, writ petition will be dismissed. Then there is no additional amount.
Correct.
you
If
need
it
to
is more
pay.
beneficial,
if there is
then
inferior, you need to pay.
Correct.
So
Yes, my lord.
I am actually with my learned counsel. In fact, sir, we both have signed the agreement. We are in consensus. We are on the both are on the
You all
one
are in
side
agreement.
to follow the agreement. So I am not saying it is your burden or our burden. I am definitely saying my JICA guidelines, if it is a less beneficial law, then it should be followed. But how it needs to be, whether it is less beneficial or not, that has to be decided by the court. Your argument is project is linear or JICA guidelines will be applicable. I am saying this is nothing to do with me. My statement is neither I am required to pay the compensation. Whatever your lordship decides, this is between the matter between petitioner and you. It is not going to impact my project obligation under the loan agreement.
My lord, I have not uttered a single word that the JICA is a necessary party. What I have been saying, this is on the application of the writ petitioner. So it is the writ petitioner who would say whether JICA is a necessary party.
And my lord,
I don't have anything to argue with the JICA as such.
My lord, section 108, the senior counsel had mentioned, my lord, only talks of an option given that can be given by the affected parties, my lord, if there is a beneficial legislation or something else. They can opt for that, my lord. It's not a situation where the state can impose the beneficial legislation on us or not. It's an option given to us.
Anyway.
Your Lordship, in fact, I think the order has already been recorded that NADCL has no objection to my application already in the previous order.
Oh.
Let me just see the order previously. 1 second.
But I am submitting today also, it is not on my application, they have been brought in as parties. So question of my objection for deletion, my lord.
That's what we asked you in the first place. You should have said that. That
Well, I've
I
been
asked
saying,
you
my lord,
whether you have,
at
what
the
is
other day, my lord, on 4/6
do you
also I have
object? I said, do you
submitted
object?
same, my
And
lord.
you started off. You
But
should
on
have-
4/6 also I have submitted same, and today also I have been submitting, my lord, from the beginning. That it is on the application of the writ petitioner, not on the basis of my application.
They will adopt the objections filed by the private respondents. Who are the private respondents?
We are the private respondents, as in the IA, my lord. We are the private respondents. That's what he's trying to say, my lord. Because
the
my lord,
IA.
writ petitions.
Okay, in
writ
the
petitions-
IA, the private.
Yes.
So, okay. So, but now you're not objecting.
We have no objection. my lord.
Now they have no objection.
As long as, my lord, the submissions are recorded.
So they are not objecting. So nothing to say, huh? Right, all right. Okay, right. Heard Miss Savita Sarna, learned counsel for the applicant. Also heard Mr. P.J. Saikya, learned senior counsel for the NHIDCL. Also heard Mr. Joseph L. Rensley for the writ petitioners. Comma Miss Caroline K. Lung Oipui for the state government, and Mr. Lien Ming Thanga appearing on behalf of the CGC. First, this is an application seeking deletion / striking out from being a party to the present writ petition. The applicant's counsel, next para, submits that the issue with regard to the payment of compensation by the state respondents to the writ petitioners pertaining to a project funded by JICA is basically an issue to be sorted out between them. JICA has no role to play in the issue of payment of compensation or the manner in which it is to be disbursed to the authorities, to the writ petitioners. Further, the issue of whether the resettlement plan to be followed by the respondents under the 2013 Act or any other model being followed by, being sought to be followed by NHIDCL and the central government would depend upon the court, who would decide as to whether which model was better suited for the writ petitioners. Correct?
My lord, she's...
Yes.
Yeah, Your Lordship, absolutely. Yeah, correct.
Right. Okay, right. Ms.
also-
Savita Sarna, next para, submits that in terms of the JICA guidelines for environmental and social considerations provided under clause 2.6 and clause 4, no, clause 2.6 and clause 4, no, 2.6 and clause 4 of the appendix 1. Shows that projects must comply with the laws, ordinances and standards related to environmental and social consideration, policies and plans of the governments that have jurisdiction over the projects. She also submits that in terms of the loan agreement dated 31/3/2017 executed between JICA and the President of India, Schedule 2 provides that Schedule 2 of the same provides that the allocation of the proceeds of the loan provided by JICA cannot be used for compensation purposes. As such, the issue raised in the writ petition with regard to the resettlement and rehabilitation of petitioners which is to be decided by the court as to which of the procedures provided in the JICA guidelines or the 2013 Act is more beneficial to the writ petitioners, would not have any effect on the on JICA. Yes,
My Lord, she had mentioned, my learned friend had submitted, my Lord, that the JICA guidelines are made for the world in general, and it is not made to override local laws, my Lord. She had mentioned this.
okay. She also submits that JICA guidelines are not meant to override the local laws in as much as they are funding projects all over the world. Correct? She accordingly submits that the JICA may be struck off as a party from the case. Mr. Joseph LLC, learned counsel for the writ petitioners, submits that he has got no objection to the deletion of JICA. Mr. P.J. Saikia, learned senior counsel for NHIDSL, also submits that he does not have any objection to JICA being deleted as a party from the case. Ms. K. Lung Oipui and Mr. Lerming Thanga also make the same submission. Correct? Is it correct? Just
Yes.
in view of the...
My Lord, I'm sorry, my Lord. I think my learned friend had also mentioned one thing. I'm not sure if it was clear. She had mentioned, my Lord, that the loan provided by JICA, Your Lordship had mentioned this, the loan provided by JICA is only with respect to the project and nothing to do with compensations.
Correct, okay.
It's already been recorded. Your Lordship has already recorded the same.
Next para. In view of the consent of the parties and keeping in view the fact that the JICA Council had specifically stated that the loan provided by JICA to the Government of India is only for the project cost and not for compensation purposes, JICA is deleted as a party from the case. The petitioner shall submit the registry to make necessary correction to the cost title.
Obliged, my lord.
After the petitioner submits a corrected cost title.
Certainly, my lord.
Because I forgot with CIS it has to be
Correct,
uploaded.
correct. We will do it, my lord.
Your Lordship, small request, if you want to mention in the order, otherwise I am just requesting this loan agreement which I have given to you right now, Your Lordship should be returned. I had no instruction to give, it was only for the eyes of Your Lordship.
Okay, I'll return it back.
Thank you so much, Your Lordship, oblige.
I is accordingly disposed of.
Thank you
And
so
the
much.
other case, in the main case, you write Mr. Joseph L. Rentley, Land Council for the writ petitioner submits that steps for service of notice upon upon Kala shall be undertaken.
Was taken today.
Has been taken today.
Yes.
Accordingly, list this matter on after puja, after vacation.
14th of July.
14 July. Obliged.
Can be on 21st of July, madam.
21st July.
21st. Obliged.
Oblige.
I don't know how CM Rem may on. An agreement.
My lord, this morning I submit my rejoinder affidavit.
Yeah, filed. Oh,
Yes.
very good.
Then and the petitioner is also personally appearing in this court today.
Okay.
And if permit, you can ask any question.
For personal appearance, I did not ask for personal appearance.
I think that you want to ask something regarding this one, how they occupy the land.
You have taken rupees 10 lakh from the tourism department.
That is for the site development, and I just want to submit that.
For the site development of your land.
Yes, site development.
They gave you 10 lakhs for developing your site.
Because there is no direct purchase. There is
So
no.
so you took 10 lakhs for developing your land.
Yes, my
Can
lord.
I also ask for developing my land? I have to develop my land.
It is not like that, my lord.
Oh.
They fraudulently occupied our land, and one of the.
Then why did you take 10 lakhs from them? And you developed their land or what, your land?
See, they at the time we negotiate in respect to our land. Then they promised me to what contract works, and they also promised me to employ one of my children in their department. Because of that only we allowed to occupy our land. But they failed to fulfill their promise. Because then during the process, the construction was going on. Then we approached the director also, and the director said that the negotiation is between men to men, and I'm going to keep my promise. Then, but soon after that, the director was go out with superannuation retirement. Then there is no direct purchase, and there is no proper land acquisition. Then if there is no direct purchase, or if there is no the land acquisition process, from my opinion, there is no right to claim any property from my land.
Then you give back the 10 lakhs to them.
How can they claim?
How can you take it, madam?
Because of the assessment.
Madam, please understand. I want to decorate my land. Will you give me 10 lakhs to decorate my land, not your land? Free of cost, no repayment, no interest, nothing.
Now they are enjoying the benefit of my land right now.
So they enjoy the benefit of it.
Yes, my land. Yes, my lord. And
I thought
I
it
just
was,
want to
it was
submit.
acquired. I thought the land was acquired.
No, actually, it's not acquired, and it was given as donation, but they requested like 10 lakhs payment, and we constructed the project that come from Central, that 484.
No, she's saying that you all are still operating the.
We constructed tourist lodge,
Ah.
and they came to know, they already knew since 2013.
That what?
And we constructed tourist lodge. And they did not have any complaint at all. And also we accompanied in 2017, they did not object at all. Only when that widening of national highway that came, then that time they refused to, they slice out some portion of land, not the whole one.
Yes.
So
yes. Where's the video stuck?
So
Where's the video stuck? Yes, now it's over.
And 2020, 21, when this notification for widening of the road came, and we make an attempt for mutation, for making land lease. And we all present, and that time they started refusing to give that land lease in our favor. So then, that time during the whole process, we occupied the land. But, Your Lordship, when that survey came, detailed survey came, that time both the survey for the crops, the maize, and for the building was made. And that for the crops, it was 11 something like something. And for that fencing, culvert, pavement, for the tourist roads, it was 7 lakhs something. So that together it's 18 lakhs. As per that guideline, Solatium should be 100%. That 18 lakhs, that 100%, Solatium is 37. That 37 exactly is deposited to their account. And prior to that, they had agreement on 17 November 2022. They were also present, tourists also present, Kala present. They put signature, they agreed. And since it was still in their name, it was deposited mistakenly to them. And on 22nd May 2023, and the DC sent a letter to the bank manager.
Why didn't you challenge the single bench order for defreezing the account?
Well, actually, that time they have come to this court without pleasing tourism department. They are the grieved party. We are not present at all. So, my lord, even from your order was very clear. You passed an order on 27 May 2025. There, you specifically directed the government to file an affidavit whether that 37 lakhs, it has to be apportioned, how it has to be apportioned. And the government filed this affidavit, and the government can explain this affidavit.
No, my question is this. She's saying that we all are enjoying the tourist lodge. Tourist lodge, I believe, has been acquired, or what? Or you all are still running a tourist
We're running a tourist lodge.
Then where's the question of acquisition?
Well, regarding that is only the compensation for our fencing, pavement, our column only.
Okay.
If you
Not
kindly-
for the tourist lodge.
That not at all.
Not
Because
that-
tourist lodge was not constructed, demolished. In between, near to that tourist lodge, that there was widening of the national highway was there. Only some portions of our building was required. The government can explain because she's the one who filed affidavit in response to your order.
Lordship, I would like.
But there are a lot of issues here.
Well, not actually, that very simple is that 37 lakhs which was deposited to them, that is for whom? That is, it was very clear in that the meeting also. The meeting minute on 17 November 2023 specifically stated that that assessment for the building should be given to tourism department. The remaining compensation should be given to them. And it was agreed by them. He was present, put signature in the meeting minute also. In pursuance to that, the money was deposited to them. In whole process, tourism department was not informed. Even this petition also, we filed impleadment application. So, and they objected also. And initially, if they impleaded tourism department, they would not have that interim order was not passed. But interim order was fortunately subject to outcome of this case.
So rejoinder has been filed today.
Yes, my lord, it is in the registrar office, I think so. Then, my lord, I would like to submit that if I donate that land, then let them produce the donation letter. Then, then, then I would like to submit that all the assessment are taken in my name upon my periodic pata,
Madam,
and
that concrete building did not come out of thin air. It was
my
built
lord,
every day.
my lord, that is illegal occupation. There is no due procedure to occupy our land. It is they occupy our land under fraud and deception. Because if they want to occupy my land, they have to fulfill their promise. They did not fulfill
Lord,
their
that
promise.
is, nothing is there. It's come
And,
afterthought only this day.
and they did not fulfill their promise, and they simply occupy our land. That is illegal occupation, my
I'll
lord.
argue this matter next week. Now everything is there. Rejoinder has been filed. So there is nothing now. I think no one can complain. We'll fix it for hearing and you do it.
Yes, my lord.
Right. Miss Jacinta Thanmoy, Land Counsel for the petitioner, submits the rejoinder affidavit has been filed today. Full stop. Mr. J.C. Lanu Sanga, no, Mr. J.C. Lanu Sanga appears for respondent number 5. Ms. Mary L. Kyangte for respondent number 4. Mr. Lianming Tanga appears on behalf of the CGC for respondent number 3, and Ms. Umar Sang Lenny Silo for respondent number 1 and 2. As pleadings are complete, list the matter for hearing in the next week.
Much obliged, Lordship.
Much obliged.
Oh.
May it please your lordship, I seek your lordship's indulgence in mentioning item number 2 of the admission list, your lordship. Your lordship, I was asked to gather information regarding the award which was made by Kala dated 22/9/2021, your lordship. I had asked for the copy of the same from the Kala Khozol. Your lordship, I have just been given bits and pieces of paper which have no dates in it. I have, if I may be allowed to submit a complete information in the form of an affidavit, if I may be granted at least 3 weeks' time, your lordship.
Item 2.
Yes, your lordship. Arbitration.
Yes, what to do?
I'm not in this matter.
Who is for the...
Mr. Zakima is on the side of the petitioners, your lordship.
no one appears for the... No one appears for the appellant. He was here in the morning?
Yes, your lordship. He was there in the morning.
Okay, right. On the prayer by Ms. Lanun Rui, then counsel for the respondent number 2. Who seeks time to
File affidavit, your lordship.
file affidavit?
Yes, your lordship.
Why
But
this appeal, madam? What affidavit?
your lordship, because the information that was given to me by the Kala Khozol, your lordship, it only has a abstract of a list of names which it does not even say anything about whether it's an award or when was the award issued. Nothing of that information is given in
No,
the
what
paper.
do you want to produce? What do you want to produce?
Your lordship, this is your lordship had inquired about the award issued by Kala on 22/9/2021, the original award, your lordship, not the arbitral award. So they have given me a list of names, but your lordship, there is no signature, there is no date as to when this award was issued. So if I
Who
may be,
submits that? Ms. London Rui, who pays for 3 weeks' time to obtain the records from Kala,
Yes,
showing
Your
the containing the original award
yes, your lordship.
for payment of compensation to the landowners. Come on, list the matter on your date. List the matter after 3 weeks.
Yes, lordship. Much obliged, your lordship.
Item number 11.
Item?
In this matter, the learned arbitrator has enhanced the valuation of the land, my lords. And my lords, I would like to take your lordship directly to the page number 153, my lords.
Yes, sir. Page 153.
Yes, my lords.
Yes.
My lords, this is a revised valuation by learned arbitrator. My lord, on the face of the award, there is no record to substantiate how these figure has been arrived at. Further, my lords, all the
What was the earlier rate?
my lords, the earlier rate is at page 35, my lords. My lord, I'll just brief you about it. The 150, it was 133.
Just a minute. 150 was?
150 was 133, my lords.
133.
Yes, my lords.
Ah.
128 was 106.
Ah.
80 was 80. 120 was 106. 100 was 85. 64 was 64 only. 90 was 80. 72 was 64. And 48 was 48 only, my lords.
And you were only concerned with BNC.
BNC, yes, my lords.
So that's all.
That's a whole issue before your lordship.
May I please lordship, my lord, the submission of my learned friend regarding the revised enhanced rate, my lord, he made a submission that there was no basis or there was no reason or evidence taken.
Correct.
My lord, in this regard, I would like to take a lordship attention to page number My lord, first of all, I would like to stress that during the hearing was conducted, my lord.
Maybe.
This is number one. And then the representatives of the appellants, they are present, both of them. And from perusal of the order of the arbitral award, my lord, it can be seen that they have never made any submission, objection, or they have not produced any evidence for the basis of the revised rate, my lord. So that is my first submission, my lord.
No, but then that will apply to you also, na?
Me also, my lord, and I'm coming to that, my lord. And then if we turn to, my lord, page number 150 of the appeal petition, para 5.2 is the submission of the Kala. So the Kala submitted that 150 numbers of sale deeds were identified for the determination of the market value. This is before on the date of the hearing, my lord. Submission of the Kala. And then from my side, from the respondent side, if I could kindly take your lordship to page number 137 of the appeal memo, my lord. 137A is the sale deed. This is the sale deed of the concerned area submitted by me, my lord, for determination of the market value. And then, my lord.
137.
137, my lord. 137A is the true type copy, my lord. 137A is the true type copy of the sale deed. This is the sale deed submitted by me.
Now, this property that has been acquired is where?
This is in Varengte, my lord.
Varengte. So
within Kolasip district.
So Varengte is the land which is acquired, correct?
My lord. And Varengte and North Simluang, my lord. Varengte and North Simluang.
Not Simluang. Is there between Dhamma?
Yes, North Simluang, my lord. So, my lord, and then, so it can be seen that these evidences were taken into consideration by the learned arbitrator.
Where does he mention this sale deed?
I'm coming to that, my lord. If we could come to para number 6, page 150.
And this sale deed was registered 3rd 3/9/21.
And my lord, 3A date is 21/5/21.
Huh?
3A notification date is 21/5.
3A notification.
3A notification date is 21 May 2021.
21 May 21. Okay.
This sale
So
deed
this
they are
sale deed
referring
is
to is
after
post.
after
Yes,
that,
absolutely.
post.
Yes, my lord.
So, my lord, in that regard, the Kala, they submitted that they have collected 150 numbers of sale deed, registered sale deeds of the Kolasip town and the relevant town for determination of the market value. However, there is no records that the sale deeds considered by them were subsequent to the date of notification of the 3A notification, my lord, which is mentioned by my learned friend 3A issued on
Mr.
21/5/2021.
Sale deeds
If we are going in that aspects, my lord.
So sale deeds have to be prior to the 3A notice.
Prior, my lord, prior to. So there is
Yours
no
is
documents
after.
on record.
Huh?
There is no documents on record as per my.
So that does not go in your favor.
So, my lord, if I may continue with the reasoning portion, para number 6, page 150. If I may read, my lord. The arguments of the learned are the comments of the Kala.
Page 150.
150, my lord. This is in para number 6 in the
Yes,
bottom
yes.
para, my lord.
Where does he mention?
It's in the
this
next
sale
page,
deed?
my lord.
Huh?
Actually, the reasoning is in the 151 page, and I'm reading first the starting of para number 6.
Okay.
the arguments of the learned AR, the comments of the Kala collective during the course of hearing, as well as the reports of the Kala.
What is AR? What is AR? What is the meaning of AR? Assam Rifles or what?
Authorized representative, my lord.
Of whom?
Of the petitioner before learned arbitrator.
Were examined and taken into consideration, page 151, para 6.1. The first question is whether such classification into several categories is justified. Admittedly, Mizoram state has an uniquely different geographical characteristics. Lands are having rare similarity, topographical advantages. The perceived advantages for commercial or even agricultural exploitation vastly differ location to location. In this consideration, the exercise of the dividing land into several grades in terms of market value by Kala is understandable, though not fully without eliminating disparities for determining just, fair, and reasonable compensation. Several factors were required to be kept in mind while fixing the market value of the acquired land. With existing geographical situation of the land, existing use of land already available, advantages like proximity to national or state highway or road and oblique or developed area and market value of the other land situated in the same locality, oblique area or adjacent or very near the acquired land already cited. So this is number one reasoning, my lord. And number two reasoning is in 6.2. As regard to judicial cases studies, though the matter emerged out of determination of market value under the 1894 Act, the requirements prescribed in Section 26 of the Right to Fair Compensation Act 2013 by and large have been addressed in various judicial pronouncements discussed herein. So the learned arbitrator is referring to those judicial pronouncements, my lords.
You see, for rate, for coming to a rate,
my lord,
how does those judicial pronouncements help you? How will it help the arbitrator? It's like saying, this car is 10 lakhs. And then what he will say, with this car you can go drive around everywhere, up the mountain, down the valley, but not saying why it should cost 10 lakhs. You should have to tell the reason why your land should be, your compensation amount should be enhanced. There's no point quoting judgments without talking about rates. When you go marketing, supposing you buy Antram, that mustard leaves, for 50 rupees here, and then a little away they sell for 80 rupees, you will go and buy the 50 rupees. You say, look, outside they are selling 80. That's why yours is cheaper, I'm buying it. So there is a comparison of rates. Outside there is no comparison of anything. You're just talking about the law and saying, the law is that when land is acquired, when land, the market value should be given, this should be done, that should be given. But how do you evaluate how much should be the price?
So, my lord, as per my understanding, and I would like to submit that all these evidences, the sale deed records and the submission of the sale deed records by the respondents herein were taken into consideration.
Where does the arbitrator say in his award that this rate is being done because of this sale deed?
This is in 7.1, my lord. 7.1, page 152. Having considered all the relevance and comprehensive criteria elaborately, 152, para number 7.1. 152, para number 7.1. If I may, my lord.
Yes.
Having considered all the relevant and comprehensive criteria elaborately discussed above.
What criteria? These are talking about Bihar land, and they're talking about laws. The grading system is rationalized for How does it matter? Probably you copy and pasted it from those judgments. I'm quite sure the arbitrator doesn't know what he's talking about. It is a copy paste of judgments of, you see, it says in the final analysis and considering the need for adoption of proper method of assessment of land revenue for determining prominent and developed settlement prime area in around so is determined as per explanation 2 to section 26. What does section explanation 2 to section 26 say? How do you classify land on the basis of judgment?
So, my lord, what I would like to impress upon this honorable court is that, my lord, the submission of my learned friend is not wholly true, my lord, since the arbitrator based his findings on these reasonings. It's not without any reason, my lord. That is what I'm trying to impress, my lord. And with regard to that, taking of evidences...
You've got to understand something. Supposing you are going to sell, say, potatoes in your shop. You are not going to read a book about potatoes and fix the rates. You are going to go to the next shop and ask, how much is your potatoes, how much are you selling? Then you'll calculate also from your wholesaler. You bought it in a bag per kg if I sell. That is how you calculate the rate. Not when you read about potatoes or you read about a cookbook, how to fry potatoes or something. The rates, at least there should be something mentioned that as per the sale deed, so, market value of this much land is this much in this area. So similarly, this also should have same rate as this. Otherwise, how are you going to, now supposing you read a book about the car, say Mercedes. You read a book about what is the good about the engine, this, that. That will not tell you how to fix the price of that. You have to see, you have to compare it. Now, supposing you see in all your locality you go. I'm quite sure your locality, if someone is selling at a cheaper price, you'll go to the cheaper fellow. Say aloo or so, dal or whatever. But how do they make it cheaper? Because they question the sale price of the other shopkeepers. Same here. How did the arbitrator come? How did it enhance the rate of the land? It has to enhance it on the basis of some document which shows that land of this type should be this type. Something. But there's no mention of that at all. And then why should he enhance grade A? Grade A is not even an issue.
That
is not his job. That is not his job also. How do we know it's only grade A? How do you say it's grade A is not involved?
My lord, that is in their petition before the arbitrator, which is at page 71.
Page 71.
It's an internal page of their petition before learned arbitrator. My lord, may see above the table, North Chinglum and Viringte.
Yes. No, but how do you say these are all pertaining to B and C, not grade A?
Oh, for that, my lords, may again come to learned arbitrator award, the same table which I have referred to, my lords, which is at page 153.
No, I agree. But how you said that none of the lands of the landowners
belongs to grade A.
How do you know whether they are grade A, B, C?
My lord, that is at page 153.
153. Yes.
My lords, may look at grade B, Viringte is there, and in grade C, North Chinglum is there.
Okay, Viringte is there in
grade B and grade C, North Chinglum.
Okay. There is no justification, Mr. Counsel. Nothing is mentioned in the award. And what does the civil court say?
That it is not against the policy of Indian law that rate has been revised on that ground. He has concluded the matter. My lords, I'll take you to the relevant para, my lords.
Page?
Page 18, my lord. Para number 23.
What the hell is wrong?
Page 18, para number
No,
23.
Where did it come out? I lose it. Page?
18, my lords. Para 23.
Yes.
In my considered view, enhancement of market value of land belonging to the respondent's landowner by taking into consideration of the prevailing market value of land within the district based upon relevant sale deed, location peculiarity, inflation of price, and location advantage of the land belonging to the respondents, it not against the natural justice and is found reasonable. In it is opine not only to the contrary to the substantive law and not against the public policy of India. Further, it is observed that the learned arbitrator Eisel has discretionary power but not to violating the relevant provision of the law to ignore the rate fixed by the Kala Kulasib to enhance the market value of the land, since the market value of the land were mainly fixed on the circumstances of the case/land and no specified fixed rate for each location was officially available. The learned arbitrator based her findings on the judicious application of mind, and it was not contrary to any statutory provision of law.
Neither here nor there. There has to be some basis. Yes, madam. You're there? Who's for Kala? Yes, what is your case?
But the instructions received from Kala and as per the submissions already made, the assessment of the land was based on the sale deeds in the surrounding areas. So we had taken the market value and all relevant factors into consideration and had given the rates. And as for the enhancement given by the arbitrator, we have no comments on that regard.
This is your appeal. Why did you put this page 137?
Manoj, 137 is there, the sale deed.
Who sealed it?
Manoj, this is a part of their petition before the learned arbitrator.
Oh,
so this was an annexure of
Okay.
there is an annexure before the learned arbitrator.
Okay. So is there an issue?
Yes.
So now let us see. Out here, what is the cost? 60 lakhs. In wiring there.
5 lakhs, my lord.
Huh?
65 lakhs, my lord. It's in page 137A.
My lord, the valuation is at page 139 based upon this sale deed.
Okay, 65 lakhs. And this is 329, 239.
Square meter.
It's in Bangla Way. And your land is where located? 239.76 square meters is equivalent to how many feet, square feet?
239.76.
Equivalent to how many?
239.76.
2572 minutes.
Huh?
2572 square feet.
2572 square feet. Now, this 2572 square feet will be how many feet? Will be how many area is 2572 square feet, correct? But how many feet are there in this 2572 square feet? How many feet is there? You mean 2572 square feet is the thing?
Is a conversion of 239 square meter.
Because this property, it's a per square feet, okay, 272 square feet. Okay, divide 65 lakhs by this 2572.
Divided
2527.
2527.
Yes, per square
So
feet.
2,527 rupees per square
Per
feet.
square feet. That was their claim before learned arbitrator.
I think Delhi should be shifted here.
So, my lord, if the case can be remanded back to the learned arbitrator to redetermine the land value and make the reasoning and the evidences, my lord. Square feet.
How did the arbitrator correct the entire line schedule of Bak, Rentekon, all that, which was not the issue here?
Category A, my lord.
Not the issue at all. And then as per your sale deed, your land should be 2,527 per square feet. It has not used the, is it correct? You calculate also. As per your sale deed, per square feet, how much will it come to?
Yes, my lord, it has come to
Then-
2527, my lord,
Then,
per square feet.
so the arbitrator has not used your sale deed. He has just gone by himself and done whatever he wants. Who is this arbitrator? Garin Zwali. Very funny arbitrator. No basis at all. So this is your only document. This is the sale deed. This is the only sale deed that you gave.
I believe so, my lord.
And you did not challenge the arbitrator's award.
No, my lord.
How can we allow you to better your case now? All some false registered document. You all have registered a false, sale deed. Those registration authorities, you see, the registration has to be done nowadays in the revenue department, correct?
My lord.
These are false cases. Try to make a fast buck. Right. Heard. Mr. Karthik Jain, learned counsel for the appellants. Also heard Mr.
Benjamin Laslamona.
Benjamin.
Laslamona.
Huh?
Lalsamona.
For the respondent number?
123528.
123528. Mr. Jonathan?
For the respondent 9.
For respondent number 9. The parents has put to the appellants. What?
Appellants, madam.
The appellants have put to challenge the impugned judgment and order dated 10/11/2025, passed by the additional district and sessions judge Kolasip, by which the appellants appeal under section 34 of the Arbitration and Conciliation Act, 1996, hereinafter referred to as the Arbitration Act. Wait. The appellants have put to challenge the impugned judgment order dated 10/11/2025, passed by the additional district session judge Kolasip in arbitration petition number 3 of 2024, by which the appellants appeal under section 34 of the Arbitration and Conciliation Act, 1996, hereinafter referred to as the 1996 Act, Arbitration Act, challenging the arbitral award, has been dismissed. The appellant's case is that the land of the respondents had been acquired under the National Highways Act, 1956, by issuing an award under section 3G of the NH Act, hereinafter referred to as the NH Act. As the private respondents were not satisfied with the compensation determined by respondent number 10. Respondent number 10, Mr. Jonathan.
9 minutes.
Not satisfied with the compensation awarded to them. By respondent number 9, comma. The respondents approached the arbitrator under section 3G, capital G, bracket 5 of the NH Act. The arbitrator enhanced the compensation amount awarded to the private respondents, comma, without there being any basis, without there being any evidence or basis for enhancement of the compensation amount. He submits that the same amounts to a patent illegality and is in conflict with the public policy of India, due to which the patent illegality, that's all. In terms of the judgment of the Supreme Court in Sangyong Engineering and Construction Company Limited versus National Highways Authority of India, bracket NHAI, comma, reported in 2019, 15 SEC 131. Yes, sir. The learned counsel for the appellant submits that submits that not only is the enhancement of the compensation on the land been made by the learned arbitrator without there being any finding that the assessment by the respondent number 9 was incorrect, comma. The learned arbitrator has enhanced the compensation amount in respect of lands which were not the subject matter of the dispute in the arbitration proceedings. He submits that while the private respondents' lands were in relation to lands located in Vairengte and North Chimluang villages, comma, which were grade B and C villages respectively, comma. The arbitrator has enhanced. The arbitrator, comma, besides enhancing grade B and C villages, has also enhanced the market value of grade A villages. Grade A towns, grade A, grade A localities in Kolasip town and other district headquarters. The learned counsel thus submits that the impugned judgment and order dated 10/11/25 passed by the additional district and session judge Kolasip and the arbitral award dated
28/3/2024.
28/3/2022.
24.
24 should be set aside. Next, Mr. Robert Lal-
No, my lord. Benjamin Lalsamwana.
Benjamin Lalsamwana submits that the learned arbitrator has based his enhancement of the market value of the lands of the respondents on the basis of a sale deed dated 3/9/2021. In respect of land sold in Vairant village, which also houses a RCC building. Has a RCC building. The area of the land is also 239.76 square meters. He accordingly submits that there is no infirmity in the learned arbitrator enhancing the compensation amount in respect of the private respondents' lands located in Vairante and North Chimluang villages. He accordingly submits that as the decision of the learned arbitrator has also been upheld by the civil court, the present appeal should be dismissed. Next, Mr. Jonathan Lalit Gaur, Senate Counsel for the respondent number 9, submits that the respondent number 9 bracket Kala had determined the market value of the lands of the respondents by this is with regard to Kolasip town, page 150.
Yes.
It has nothing to do with Vairante.
But since specific sale deeds were not available for buying, there's some relevant close by.
Okay, what do I
sale deeds
say?
for example.
Respondents by considering 150 registered sale deeds pertaining to Kolasip town area, come in as much as there were no sale deeds for determining the market value of the land in Vairante and North Chimluang villages, during the time of making the award. When was the award made, Mr. Counsel? Award under 3G.
May I assist, Your Lordship?
انت صوت لك كالندر صدق عبودي ولا فرعون كده يبقى شهرين شو كالندر اكيد انت زي احنا كده page
Well, it's page 44,
look at page
12th.
44. You don't know. You're for Kala and you don't know.
Lordship, as per the page 44 of the revised 3G was submitted on 12th May 2022. 12th May 2022.
CD notification was issued on
Notification.
17/12 and 3G when?
3G was submitted on 12th May 2022.
How do you say that? 12 May. Okay.
That is the submission of 3G revised estimate. Page 44, Your Lordship.
Revised estimate.
Yes, Your Lordship.
What about the earlier one? Without the revision, how much?
Earlier one is at page 35.
Okay, right. He submits that prior to submission of the 3G revised estimate on 12/5/2022, the following exercise has been undertaken by Kala. Page 44, 1, 2, 3, 4, 4, huh? 1, 2, 3, 4. 1, 2, 3, 4. 1, 2, 3, 4. Okay. Next. Next, he accordingly submits that. No, of course, that's all. Huh? Next, I have heard the causes for the parties. As can be seen from the records, the market rate fixed by the respondent number 9 for acquiring the lands of the private respondents had been done on the basis of 150 registered sale deeds pertaining to localities within Kolasip town and other district headquarters. So, the lands of the private respondents which were located in Vairengte and North Chimluang villages were given the benefit of the rates fixed for Kolasip town. So, the arbitral award, the learned arbitrator has enhanced the as per the records, Vairengte is a grade B. Notified town, while North Chimluang is a grade C village. The rates fixed by, I think this is for government rates, I think this is. This is the government rates, no? This one? Huh? Is this the government rates that fixing?
My lord,
In
the
Kala?
rate by Kala.
Okay.
My lord, he has
The
determined that
rates fixed by Kala. The rates fixed by the government and Kala.
Kala determines the rate.
Huh?
Kala usually determines the rate. He's an independent body.
The rates fixed by Kala for grade A, B, and C towns and villages are as follows. In yesterday's order, Amasazoka, chart next para. The arbitrator's enhanced rate of land value is as follows. The same, there are two charts out there. Next para. As can be seen from the above, there is an increase in the land value made by the learned arbitrator in respect of all the three grades of lands, even though none of the respondents, private respondents, had any land had any grade A land. The arbitrator has on his own enhanced the land value for grade A towns / district headquarters. A reading of the next para. A reading of the arbitral award does not show the basis or reason as to why there has been enhancement of the rates of the lands of the private respondents. The learned arbitrator has only parroted, has only recorded the law laid down by the Supreme Court with respect to acquisition of land. And there is no discussion or findings made by the learned arbitrator as to why the rates have been enhanced. Full stop. Next paragraph. Though the learned counsel for the respondent, private respondents has relied upon the sale deed dated 3/9/2021 in support of his submission that the said sale deed had been relied upon by the learned arbitrator to enhance the compensation rate payable to the private respondents, comma. This court is not convinced of this court is not convinced with the said argument. So firstly, the sale deed dated firstly there is no mention of the sale deed dated 3/9/21 by the learned arbitrator in his arbitral award. Before that, in the sale deed dated in the sale deed dated 3/9/2021, land and building covered by LAC/P Pata number VRT-1 of 1996, located at Banglaveng, Vairengte, having an area of 239.76 square meters, which also housed an RCC building, had been sold for rupees 65 lakhs. Full stop. Then the firstly, secondly, the sale deed dated 3/9/2021 is not only with regard to sale of land, but also of an RCC building. It is not the case of any of the private respondents hearing that their lands have RCC buildings located on their lands, which were required to be acquired. Full stop. Next. Thirdly, if the rate of rupees 65 lakhs was to be applied for were to be accepted as the market value of 239.76 square meters, the same would work out to be rupees 2527 for 1 square feet. Full stop. Which is not at all the case of the private respondents in this case, or before the arbiter, the learned arbitrator. Full stop. Next paragraph. On going through the next paragraph, there is no reason given by the arbitrator in his award for enhancing the rate of compensation of the private respondent. Also, it is not understood as to how, before that, fourthly, fourthly, when the sale deed dated 3/9/2021 pertains to Vairante village, Vairante town, it is not understood as to how the same can be applied to land pertaining to North Chimdwang village, which is a small village independent of Vairante. Then you come back, huh? As to how the recording, how the law laid down by the Supreme Court, which has been put into the award, would decide the actual monetary value of land. There is no reference to any market value or sale deed or any document by the learned arbitrator, which could be the reason for enhancing the market value of the private lands or the private respondents, the land of the private respondents. There is also no observation or finding that the compensation amount assessed by the respondent number 9 was not correct. Full stop. Next paragraph. In the case of dash versus dash, the Supreme Court has held that a decision without any reasons is violative of Article 14 of the Constitution. Next, in the case of Sangyao Supra, the Supreme Court has held that I'll give you the data. Then next, in the case of dash Tilera, next para, in the case of dash Tilera. So basically, dismiss. Not dismiss, sorry, allowed.
My lord, the case may be kindly remanded back to the learned arbitrator, my lord.
On what basis are they going to decide?
To reconsider and to clarify the reasoning, my lord. So it may be kindly in this aspect, my lord.
But on what basis, you tell me? You cannot file additional documents now. You'll be making up documents.
Yes, my lord, that is there, but to give a chance for the arbitrator to give the reasoning, my lord, and what he has based on, my lord. So it may be kindly remanded
You have
back.
got to show me, you have got to tell me. There is no mistake by Kala. Kala has done it. And I will see. Basically dismissed. Next.
Also for item 1.
Maybe the basic grievance of the petitioners is the exclusion from the final interstate seniority list of ward superintendents and working under the government of Mizoram Health and Family Welfare Department, who were appointed between 2016 and 2024.
2016 and 24.
Yes.
So what about before 2016?
Yashba, we have no idea. I mean, we are concerned only with this because we were appointed during this period, 16 to 24.
Let us see your appointment orders and advertisement.
Yes. I'll take your lordship to page 25. This is the post-creation order. At page 25, annexure 1.
25?
Page 25.
What is this matter you gave me? RFA, you gave me RFA. RFA is fixed for tomorrow, no? Item 1, I think. This is the hearing, this is a hearing. And there is a sketch map of a house. Thinking, where am I?
Part 1, item 1.
Part 1, item 1. Kelal Tlanpui. Oh. Even back.
Otherwise, it can come up next week because in the meantime, I've told my friends also, Learned Council for the Private Respondents, there's a Mizoram State Cancer Institute. There also, the nurses working there were also appointed for that institute. But they have been included in the common seniority list of nurses working under the Health and Family Welfare Department. Our case out here is that we have been appointed for initiative for Myanmar, which is now called ZMC and State Referral Hospital, under the Health and Family Welfare Department in the year 2018. So in spite of that fact that we were appointed by the government of Mizoram, Health and Family Welfare Department, we have been excluded from the common seniority list of ward superintendent working under the Health and Family Welfare Department, government of Mizoram. Our case is that the post creation was made by the government of Mizoram for Myanmar under Health and Family Welfare Department. And even the selection was done as per the recruitment rules framed by the government of Mizoram.
No, but these have to be made somehow. And,
Yes.
Then
So our main claim is that we hold cadre posts of ward superintendent under the Health and Family Welfare Department. Post creation is made by the government of Mizoram. Advertisement also shows that we have been recruited.
you see, even in these centrally sponsored schemes,
Yes.
post creation has to be done by the government, but that does not mean that they become government servants.
But you should be, we have been appointed by the government itself.
You have to be appointed. There's no one else to appoint you. How do you expect?
But
it's a new institution that has come up.
Yes.
Who do you expect to appoint?
And Yoship, now the state government has issued a notification that it is a government institution.
Maybe a government institution,
So
but
they-
it is a
and-
different, it's a different establishment.
But there's nothing in the post-creation order stating that the ward superintendents appointed for Myanmar under Health and Family Welfare Department will form a separate cadre.
They can take the decision anytime that.
They have not taken the decision, Your Honor.
And it's a society, I think.
No, that's been cancelled.
The RMC is not a
Yes.
society.
Yeah, if you all also will see in the affidavit filed by the state.
Okay, acha, that is it. Oh. Okay, you all want to do it next week, we can do it, no point.
Yeah. In the meantime, I can furnish the appointment orders of those nurses, ward superintendents appointed under the Mizoram State Cancer Institute.
That's a different thing.
That's a different institute, sir.
That's a different institution.
But they are included in the common seniority list.
Maybe they
So that
want
is
to.
why
They
you're-
want to include them
So that-
unless they make the post transferable. I don't know if we have got a right.
Anyway, in the meantime, let me satisfy the court that
Oh, you all want to do hearing? I am ready. Either way.
I don't know whether that will be necessary, my lord, that Cancer Institute, that issue, because
that
No,
is
no,
also-
that has got no relevance.
that is also a
Yes.
separate institution.
Huh?
That is also a separate
So what?
institution.
It depends upon the government who they want to include among that inter-transfer posts,
That is why
inter-transferable posts.
my submission, I've just received information that those persons working there were also appointed for the institute, but they have been included in the common institute.
They can do that. Government has got the power. They are the ones who
So
are.
in our case also, we have been appointed by
They
the
have got
government.
no right. You got no right.
We
That
have
is.
been appointed by the government.
So what? It has to be. Who do you think will appoint for
No,
them
Your Worship,
at the time?
now they're saying it's an institute, there is a society. We have been appointed by the society. We are governed by that. Now, latest in 2025, they issued an order saying that it's a government institution.
but there is conditional, my lord. The last paragraph says that all the rules governing the college and hospital shall continue to remain in force.
How will those rules?
And it doesn't matter. You see, even High Court, we use the government rules for appointment of grade 3, grade 4 times sometimes
Yes.
because we don't have the rules. That does not make them government employees. They are still High Court employees.
Right.
Yes, Your Worship,
So
but
just
then-
because we utilize government service rules doesn't make them government servants. I mean under their control. It is under the High Court control. Same thing.
Yes, they cannot treat it at par, my lord, with the government.
Yeah, no.
the
Yes.
situation is a bit different here.
But you have to. If you are ready, I can hear you.
Your
No
Worship,
problem.
if it may come next week, I may be given a chance to get hold of these orders passed by the Mizoram State Cancer Institute.
How will that help
No, Your
you?
Worship, my submission now is that those persons were also appointed for that cancer institute, but they have been included in the common seniority list.
That is the prerogative of the government. They
now
can do
the
that.
stand is here. Now the stand they have taken is that since we were appointed for ZMC, initially known as Myanmar, so we cannot be included in the common seniority list.
So what is
but
wrong?
then if they can
What is wrong?
If
Because
they-
that way, no, you will not go out. No one can come in also.
No,
to
but
your,
then
no one can come into your service also.
chances
From
of
outside,
promotion-
now health and family welfare people will not say that there is a vacancy in ZMC. I should be also considered. What right of yours violated?
No,
I
no,
don't
my
know.
promotional chances have been affected.
Where?
If I'm included in the common seniority list, then I have
You are
larger
in
chances.
ZMC. You are in ZMC.
Sure, that is why. But if I'm included in the common seniority list of ward superintendent,
Anyway, we'll
It
see.
may be taken up on this coming Wednesday at least, my lord. Now it has been pending since 2024.
we can have it on Monday, Ashok. There are so many fixed items.
Thursday also you can do it. It's not a complicated issue. my
I think Malana friend is got the pulse of the court.
lord. No. Because
And you also got the pulse of the court.
Yeah, before your Lordship, the Cancer Institute superintendent, board superintendent nurses, I think that will have a bearing because that's a separate institute, but those working there have also been included.
You see, the government has the authority to decide which institute it wants to have, to have inter-transferable posts.
Let them produce
with
the
department.
decision. Let them produce such decision if
Huh?
there is.
No,
let
it's
them-
not necessary
Let
as
them
of now, my
produce
lord.
such a decision saying that the ward superintendent of ZMC form a separate cadre. If there's a decision of the government, I bow down to it. But
let the government take a decision.
there's no decision. Let them produce
But
it.
then no, but then it is already inbuilt. Could be already
No,
inbuilt.
it's not inbuilt, Your Worship. Your Worship,
You see,
post-
the RDA staff, when the scheme was formulated, all the staff were appointed by the government. The posts were created by the government, but they were not in the government establishment. Then they had to file writ petitions to come into the government. So that does not mean that just because they were appointed by the government, posts created by the government.
that was a central sponsored scheme.
Correct.
This is not a scheme.
So what?
This is not a central
What
sponsored
is this?
scheme.
What is this?
This is not this is a government institution. We are working under the government of
You
Mizoram.
see, just because you are a government institution doesn't mean that you are part of the government. You can be a separate, it can have a separate institution.
If a decision is made by the government,
They've made it. That's why you're
they
filing
have
the
not
case.
made it.
That's why you're filing this case.
If it's a decision,
Okay, we'll hear.
We could have challenged it, Your Worship, if the decision
We'll hear
was
you.
there.
We'll
So
hear you.
Let me give it. Let me get.
We'll hear you. I'll correct. I'll
Let me get
clarify
a
all
chance
this.
to get those orders of the State Cancer Institute.
How will it help?
Because that is a separate institution, but they are part of the common pool.
I don't know. We can start. There's no problem.
Okay. My letter. Your Worship, I'll take your lordship to the Annexure 1. Page 25.
Annexure 1. Yes.
This is the post-creation order.
Yes.
In the
Just a
interest-
minute. Just a minute. Page 25.
Annexure.
14/11, 2017.
In the interest of public service, the Governor of Mizoram pleased to accord sanction to the creation of following 629 various posts for establishment of Mizoram Institute of Medical Education Research under Health and Family Welfare Department. Now, I'd like to stress on the wording under Health and Family Welfare
Yes,
Department.
yes.
Page 31, Your Worship, 30 posts have been created. Page 31. The last box, hospital nursing service, teaching hospital, serial number 3. Ward superintendent, 30 posts have been created. And this is with the approval of DPNAR, Finance Department, meeting of Council of Ministers, etc. And then page 33, Your Worship.
Yes.
This is the proposal sent by the government, Health Department to the Secretary MPSC, proposal for recruitment of staff nurse and ward superintendent for Mizoram State Institute of Medical Education Research. In continuation of this department of even number, I am directed to forward herewith a proposal for recruitment of staff nurse and ward superintendent as per the relevant recruitment rules, as listed below. So this is ward superintendent, so number of posts 31. Page 34, Your Worship. This is the,
But so there was a creation of one more post. Huh?
here appears, Your Worship, but only 30 were appointed anyway.
Yes.
Your Worship, then the recruitment, page 34, qualification is as per the recruitment rules. Page 34, qualification BSc Nursing of recognized university. Number 2, diploma of recognized university in any field of nursing having 1 year experience in staff nurse. Number 3, working knowledge of Mizo language or middle school standard is desirable. The rest is basic knowledge of computer. It's all or.
Yeah.
Then Your Worship will see page 37 is the recruitment rules of 1992. So we were recruited as per the recruitment rules of 1992. And again at page 41, Your Worship,
Page 40?
1 is the advertisement. I'd like to stress on the first sentence, Your Worship. Anway talan hatei Myanmar Health and Family Welfare Department wire. So again, Your Worship, it's always under the Health and Family Welfare Department. Even the advertisement, even the proposal.
Yes.
Then Your Worship.
Where is the appointment orders?
Yes, Your Worship will see page 47. This is the recommendation. Candidates recommended for appointment to the post of Ward Superintendent, Mizoram Institute of Medical Education Research under Health and Family Welfare Department. Again, recommendation also. Then, Your Lordship will kindly see page 50. Page 50, Your Lordship, offer of appointment. If I may read this. On the basis of your performance in the examination for direct recruitment of Ward Superintendent conducted from so-and-so and recommendation by MPSC white letter dated so-and-so, Government of Mizoram is pleased to offer you an appointment to the post of Ward Superintendent. It is always the Government of Mizoram. This is just one of the letter of offer of appointment given to one of the petitioners. Page 55, Your Worship.
Yes.
Is the appointment order.
Yes.
On the recommendation of MPSC conveyed by Government of Mizoram Health and Family Welfare Department and subject to production of authorized medical fitness certificate and police verification of character and antecedent report, the following persons are hereby appointed to the post of Ward Superintendent for Myanmar with so-and-so. And this appointment order has been issued by the Principal Director, Health and Family Welfare.
When was this Myanmar ZMC established? Anyway, it doesn't make a difference.
I'm not aware of the exact, but it was registered as a society on 14th of September 2018. 14th of September 2018, it was registered as a society. So, as your Lordship will see, the appointment order came out before it was registered as a society.
No, you said 2017 or 19?
No, the society registration.
Yes.
Society registration is 14th of September 2018.
Okay.
The appointment order of the petitioners 1 to 29 is 30th of May 2018. Before it was registered as a society.
Doesn't matter. Yes.
Then you have to page 58, annexure 8, is the appointment order of the petition number 30. This is again, this has been signed by the Secretary to the Government of Mizoram Health and Family Welfare and Chairman Executive Committee, Myanmar. So, except for petitioner number 30, petitioner number 1 to 29 have been appointed by the Principal Director, Health and Family Welfare. The petitioner number 30 was on the panel list. So that is why there's a delay of nearly 1 year in her appointment order. Then, Your Worship, at page 60 is the office order regarding confirmation of the services of the petitioners. Again, if Your Lordship will see at page 63,
60.
page 60 is the confirmation order. Page 60 is the confirmation order, Your Worship. At page 63, this issues, page 63, Your Worship. This issues with the approval of Government of Mizoram Health and Family Welfare Department. So it is always the Health and Family Welfare Department which is the approving authority. Page 64 is the confirmation order of the petitioner number 30. Page 64 is the confirmation order of the petitioner number 30, whose name appears at serial number 1, Your Worship. Again, at page 65, you will see that it is issued with the approval of the Government of Mizoram Health and Family Welfare Department. Then, Your Worship, at page 66 is the provisional inter-se seniority of ward superintendents appointed between 2016 to 2024 under Health and Family Welfare Department. We were excluded out here. We submitted our representations, which is at page 69. And if Your Lordship will see, at page 71.
Yes.
This is, the provisional was issued on 4th of April 2024 by the Director Nursing. We submitted our representations, and page 71, Your Worship.
Yes.
This is the circular. If I may read this, Your Worship. A provisional inter-se seniority of ward superintendent has been fixed by the Director Nursing, Directorate of Nursing, for those who were appointed between 2016 to 2024 under Health and Family Welfare Department. Any person feeling aggrieved in this regard may submit his or her grievance along with documentary proof to the undersigned within 30 days from the date of issue of the order for further submission to the Director Nursing, Directorate of Nursing and Health and Family Welfare Department. So even the Director of ZMC had issued this circular giving opportunity to the petitioners to submit their representations against the provisional inter-se seniority list dated 4th of April 2024. Again, we submitted our representations, but there was no reply from the state. And at page 74 is the final inter-se seniority list, where we have been excluded. So my humble submission, Your Worship, is that the post created was for MIMER, but it was under Health and Family Welfare Department, Government of Mizoram. Even the appointment orders were passed by the Government of Mizoram. And there's no document to show that the post of ward superintendent created for MIMER, now ZMC, and now the name has further been changed. Now it is Zorab Medical College and Hospital Falcon. There is no decision of the government to show that the ward superintendent under ZMC will form a separate cadre from the ward superintendent post under the Health and Family Welfare Department. even the fact that the advertisement states that it will be under Health and Health Welfare Department, even the 92 recruitment rules for ward superintendent has been used for recruiting us. So, and we were appointed in 2018, May. The MIMA was registered as a society in September 2018. And if I may take your lordship to the minutes of the MPSC recommendation.
You were on probation.
Yes.
With me.
If I may take your lordship to the affidavit filed by the state.
Yes.
At page 37. Roman annexure 4, page 37.
Yes.
These are the minutes of the meeting of the MPSC to consider appointment to the post of ward superintendent, held during 17th to 23rd April 2018. And Your Worship, it is clearly mentioned here. Second paragraph. According to Mizoram Health and Family Welfare Department, Group P, Non-Gazetted Recruitment Rules 1992. We were selected as per the recruitment rules. And at the bottom of the page, Your Lordship will see, on the basis of this, the Commission recommended appointment of undermentioned candidates to the post of Ward Superintendent, MIMER, under Health and Family Welfare Department.
Where are you reading?
Page 37, bottom.
On the basis of this.
Annexure Roman 8, Your Worship. And I'll just take Your Lordship to Annexure Roman 8 of the affidavit filed by the state.
Page?
I'm just the certificate of registration, Your Worship. Page 60. This is the certificate of registration. This is dated 14th of September 2018. The petitioners number 1 to 29 were appointed on 30th of May 2018, before it was registered as a society. So your viable submission at this stage is that there is no decision on record made by the government that the ward superintendent appointed under MIMER, ZMC, whatever, will be treated as a separate cadre. Throughout post-creation, advertisement, appointment orders, everything shows that we have been appointed as ward superintendent for MIMER under Health and Family Welfare Department. So there's the decision, if there's a decision to treat us as a separate cadre, then we would have had to challenge it, or we would have accepted it. But when there's no decision to treat us as ex-cadre posts, how can they exclude us from the...
But now if they make a notification now, you said this proves that prior to that there was no...
Yes, now if they come up with such notification, then the only cause will be to challenge it. But as on date, there's no decision of the government.
Your confirmation was to a... Your confirmation...
Yes.
Was to a society, not to the government.
No, Your Worship will see
The wording doesn't matter.
The society has been discussed. Your Worship will see at page, affidavit of the state, page 170.
170.
This is notification dated 29 January 2025. As per decision at item number 6 of the Council of Ministers in its meeting on 20th of December 2024, white number so and so, dated 20th December 24, Governor of Mizoram is pleased to order conversion of the Zoram Medical College Society into fully government medical institution with immediate effect. Consequent upon the conversion, Zoram Medical College shall comprise of the Zoram Medical College and State Referral Hospital Falcon, and it shall be known as the Zoram Medical College and Hospital Falcon. So it has been converted into a fully government medical institution. So the society stage has already been passed over. The Governor of Mizoram further pleased to order that the management of the college and hospital and all rules governing the college and hospital shall continue to enforce till new rules and regulations are framed and notified by the government. So when ZMC and the state referral hospital where we are working has become a fully government medical institution, Your Worship, the rules and regulations of the society are no longer there. We are appointed under the government of Mizoram Health and Family Welfare Department. There's no decision to treat us as a separate cadre. How can they exclude us from the seniority list of ward superintendent under the Health and Family Welfare Department, government of Mizoram?
No, but it may be, so it has, is the society registration cancelled? What has happened to the society registration? So it's no longer a society.
However, my lord, in that notification, it is written that the Governor of Mizoram is further pleased to order that the management of the college and hospital and all rules governing the college and hospital shall continue to remain in force till new rules and regulations are framed and notified by the government.
Where is the college hospital rules governing the college and hospital?
Your Worship, we were not given an option when these rules and regulations were made. We were appointed by the government.
Naturally, you should be lucky that you got a job.
Yes, Your Worship, I mean, who's not happy to get a job? But Your Worship, we are not happy with the fact that we have been excluded from this cadre.
Even
I mean,
if
it's not that it's a handout, Your Worship. You
are lucky to get a job. If it was in Timbuktu, you'd still go there also for a job.
It is on the basis of merit we have been appointed.
Anyway, I think let us hear the other
Your
side.
Lordship, the rules is at
You've got some citation?
Yes.
Yes, give me the citation.
2015 1 GLT 269.
2015 1 GLT.
Volume 1 GLT 269.
Yes.
This was a case, Your Worship, regarding lecturers of diet. Under the state of Assam, there were various diets. Each diet had various branches. So early on, the seniority lists of lecturers of diet were fixed according to the different branches in a diet. Then,
yes,
Your Worship will see, I'll just read the important points. Para 3, I'll read Para 2 and Para 3. Issue raised in the two writ petitions is whether gradation of list of lecturers serving in the diet should be department/branch wise or cadre wise. This issue has arisen in the context of the Assam District Institute of Education and Training Service Rules 2010, Diet Service Rules hereinafter. While the petitioners contend that the gradation list of lecturers has to be department/branch wise, the respondents contend otherwise. So now if I'll take your lordship to Para 5, on the right side, Your Worship, there are two columns on the right side. Line number 6. A diet comprises of various branches. Has Your Lordship got it? So there are number of branches. At the end of para 5, in all there are 7 branches in diet. So there are various diets, and each diet has various branches, and there are 7 branches in a diet. And Your Worship, according to the petitioners, they are eligible for promotion to the post of senior lecturer. As per diet service rules, respondents had in the past prepared gradation lists of lecturers of diet, branch-wise, as per recommendation of APSC. After enactment of the diet service rules, similar gradation list was prepared in the year 2013. One Sri Ratul Nyo, a lecturer of diet Nagaon, had raised objection by filing representation for preparation of gradation lists branch-wise. He contended that gradation list should be prepared cadre-wise, irrespective of branches. That is, for the cadre of lecturers, there should be one common gradation list. Contending that his objection was not being considered, he moved this court by filing writ petition number so and so. This court, after noticing the grievance expressed by the said Ratul Nyo, disposed of the writ petition by order dated 12/3/2014 with a direction to the respondents to consider the objection raised and to take a decision thereafter in accordance with law. Petitioners also approached this court by filing WPC number so and so, contending that the gradation list should be prepared branch/department wise and that there should not be one common gradation list of lecturer. This court, by order dated so and so, disposed of the writ petition by directing the respondents to take into consideration the grievance raised by the petitioners, also while attending to the grievance raised by Ratul Nyo. Para 7. Following the same, Secretary to the Government of Assam, Education Elementary Department, passed an order dated 17/6/2014, declaring that gradation list of senior lecturers and lecturers of diet in Assam would be prepared cadre-wise. And we have already said, Your Worship, the diet has 7 branches. Early on, the seniority list was made branch-wise, department-wise, but now
You see, the issue here is slightly different. This pertains to diet. It would have been another case if the lecturers in diet were also allowed to be in the seniority list of lecturers in the education department. In your case, it is an issue with the institution of ZMC, which is separate from the government directorate and the office.
My humble submission, Your Worship, if I may be allowed.
Yes.
We are all ward superintendents under the Health and Family Welfare Department, Government of Mizoram. We may be posted, we may be appointed for Myanmar, but under Health and Family Welfare. And there is no decision made by the government that ward superintendents under Myanmar will form a separate cadre. We are holding the same post, same pay, same responsibilities. Now, if I may take our to para 22.
Yes.
If I may read para 22. Fundamental Rule 9 subclause 4 defines cadre to mean the strength of a service or part of a service sanctioned as a separate unit. On the other hand, Fundamental Rule 9 subclause 22 defines permanent post to mean a post carrying a definite rate of pay sanctioned without limit of time, while a temporary post under Fundamental Rule 9 subclause 30 means a post carrying a definite rate of pay sanctioned but for limited time. From a reading of Fundamental Rule 922 and 930, it can be said that a post can be permanent or temporary. In both cases, it carries a definite rate of pay sanctioned. As such, post can be described as a single unit of service assigned with specific duties and responsibilities carrying a definite rate of pay sanctioned. On the other hand, cadre under Fundamental Rule 9, subclause 4, has been defined to mean the strength of a service or a part of the service sanctioned as a separate unit. Therefore, conceptually, cadre is a larger unit of the service and post is a single unit of the service. Viewed in that context, cadre can be said to be the genus and post as species. A cadre may include a number of posts within its fold. Posts can be permanent or temporary. However, in a given case, a cadre may consist of a single post, that is, there can be a single post cadre. As stated above, a cadre may comprise of a number of posts, but to be part of the common cadre, the post, when there is plurality of posts in a cadre must meet or fulfill certain essential preconditions. The nature of duties of the post should be similar. The post should carry identical or similar responsibilities. The pay scale of the post must be the same. The content of duty or qualification prescribed for recruitment to different posts may differ, but that will not make any material difference to the inclusion of posts in a particular cadre if the essential attributes as indicated above are fulfilled. Again, within a common cadre, there can be different grades, which is within the competence of government to create. So, as stated above, a cadre may comprise of a number of posts, but to be part of the common cadre, the post, when there is plurality of posts in a cadre, must meet or fulfill certain essential preconditions. Number one, nature of duties of the post should be similar. Two, the post should carry identical or similar responsibilities. The pay scale should be the same. So now, if I take your lordship to the recruitment rules of ward superintendent, which is at page 37 of the writ petition.
Yes.
So these are the recruitment rules of 1992 for the post of ward superintendent, which was earlier.
Page 37 is the MPSC minutes.
Annexure 3, Your Lordship, of the writ petition.
Yes.
So the post of ward superintendent was earlier known as sister, but it was redesignated and referred to as ward superintendent. So
So this ward superintendent, as
Yes.
per the rules here,
yes,
there are 31 posts.
page 39, column 2.
Column 2. Yes.
Yep. 36 posts or varies from time to time.
Okay. So
Early on, when the rules were made, there were 36 posts, and subsequently been
now
increased.
the issue is this. The issue is this. Madam, please listen. As per the rules, the ward superintendent post was there as per the rules. How many, as per the rules, as per these rules, how many ward superintendent posts are there? Now, the latest, as per the rule.
31.
Now, forget the ZMC. As per the rule, how many existing sanctioned posts is there? How many persons are working as ward superintendent? Then you see, you keep now supposing there are now at today say there are 50 ward superintendent. If 50 is occupied and there's 30 there, naturally those persons are not in these rules. Otherwise, the rules will have to be also amended to put in the number of posts, sanctioned posts. So whether those ZMC ward superintendent posts have been included in these rules.
Lordship, it's there at page 161 of
161.
my affidavit in opposition.
161. 161. Okay. 161. This is the President, the governor, please to know, Zora Medical. Okay, Zora Medical College, you have got a different rule. Okay, you
Yep,
already
this,
have that.
yep, this is during the society, period of the society.
But that will still apply. Naturally, it will still apply.
We were appointed much before the society was also created, Your Lordship.
Doesn't matter. Doesn't
This-
matter. But it was in anticipation of this. Someone has to come first. Either the chicken or the egg has
Yes,
to come first.
so we came before this. We were not given any option.
You were you appointed in terms of the sanctioned posts in the rules or beyond the posts in the sanction? You see, as per, I want to know, forget this Zoram Medical College rules. As per the Family Health and Welfare Department rules, for ward superintendent, there is a recruitment rule. There is the number of sanctioned posts there. In the year 2016, how many sanctioned posts were there in that rules? And how many were working there? and now you compare that with these. So if the total is beyond that number in the thing, they were not included in the sanctioned post out here. That is clear. So you understand what I'm trying to say. So the issue is, on the day that the recruitment was done, the advertisement was issued for ZMC post, in the health department, how many ward assistants were actually working, and how many posts was there in the rules at that time? So in the rules at that time, say there were 30 posts, and there were 30 persons working. The appointment of these persons cannot come within that rules. So they were outside the sanctioned post. So just take that.
The rule, if I may, the rule says varies from time to time.
That's why I'm asking that. That's why they have to bring.
And 2017, more posts were created.
No.
And we were appointed as per the rules.
Let them get the rules. That is all right. You see, like I said, the Gauhati High Court, for grade 4, in Assam, we use the Assam government rules. In Aizawl, Mizoram, we use the Mizoram. We don't have a separate Aizawl bench grade 4 post rules. We don't have. For Arunachal also, Nagaland also. So that does not make them government.
But there's a slight difference there. We are appointed by Health and Family Welfare
Maybe
Department.
you have to be
We are working under the Health and Family Welfare
Who do you want to be appointed?
We are not working for the High Court or a society anymore. It is a government institution, Your Worship.
Okay. Just let her get the information. Let her get the information on that, and then that will solve the entire problem.
Because
you see, as per the Health and Family Welfare Rules of 1992, I think you're saying.
Yes.
1992, there were only 30 sanctioned posts of ward assistant. So on the date that the advertisement was issued for ZMC, how many were already working for the government at that time as ward assistant, as ward superintendent, and how many sanctioned posts had been added by then? It must have multiplied a little bit. So if, say, that 30 posts had now been expanded to, say, 40 posts, and there were already, say, 35 persons working or 40 persons working, and these 30 persons were not appointed for those posts, because you cannot appoint beyond the rules. So just bring that.
My humble submission, Your Worship, and that the rules says varies from time to time. Just because the rules have not been amended to include the subsequently created posts, that cannot mean.
No, amended from time to time doesn't mean that it is left in thin air.
No, but
that also amended has to be. Posts have to be created.
I understand what Your Lordship is getting at.
Yes,
but my humble submission, Your Lordship, is that posts were created by the government. Now it is for the government to amend the rules. If they don't amend it, why should the petitioners suffer?
You bring that tomorrow. Leave the matter tomorrow.
Part 2 hearing item. Item number 2.
Or is it this not the hearing, no? What is this matter? Item?
Item number 2 of hearing list, my lord.
Oh.
Is regarding freezing of the petitioner's bank account. Freezing of petitioner's bank account by the respondent.
Item 2 of this.
Hearing list from part 2.
Where is your affidavit of notice on the respondent?
My lord, since the service was completed by way of taking the postal consignment, that was already deemed complete as per the order dated 19/2/2026, my lord.
Yes, as per the order dated 19/2,
Para 2.
19/2.
Para 2. Order dated 19/2/2026, Para 2.
Okay.
These respondent 2 and 3 were in fact the cybercrime police station from Tamil Nadu and Maharashtra respectively. So there's difficulty in taking steps by way of Dasti, and I have sought for.
Anyway, there's no time now, I think.
Yes.
Next week.
Next week, no
Anytime.
problem, my lord.
Hmm?
Yes, it may be taken up next week also.
Because we have fixed this matter also. I don't know whether you'll be able to get the information in time, but then, well, if you can get, then we can take it up. If you're not, then we'll have to adjourn, I think. Anyway, right. Due to on the prayer, the party leaves the matter in the next week.
Super.
Deeply obliged.